Let us pray. Almighty God, we willingly acknowledge you as the supreme being, most gracious and most merciful. Look down, we beseech you, on us who are members of this Senate, and deign to assist us in the duties that we have to perform on behalf of our beloved country of Trinidad and Tobago. Open our eyes to see the truth, and help us to accept it with all its implications into our lives. Direct us, O Lord, in our deliberations, so that setting aside private interests, unwholesome prejudices, and personal affections, we may treat all matters set before us with honesty, courage, and conviction. Through all we say and do in this Senate, may we give glory and honor to your holy name, inspire confidence in our fellow citizens, and make a positive contribution to the peace and prosperity of our nation. Amen.
Announcements by the President.
Honourable Senators, leave of absence has been granted to Senator the Honourable Alison West, who is out of the country. Honourable Senators, I will revert to this item on the order paper later in the proceedings.
Bills brought from the House of Representatives appearing on the supplemental order paper. The National Insurance Amendment Bill 2022 in the name of the Minister of Finance. Papers.
Acting Leader of Government Business.
Thank you, Madam President. Madam President, I have the honor to lay on the table the following papers as listed on the supplemental order paper in the name of the Minister of Public Utilities. The annual audited financial statements of the Water and Sewerage Authority for the financial year ended September 30th, 2017. The annual audited unconsolidated financial statements of the Trinidad and Tobago Electricity Commission for the year ended December 31st, 2019.
Urgent questions.
Senator Richards.
Good afternoon, colleagues. Thank you, Madam President. To the Minister of National Security, in light of the recent warnings issued by the Minister of Health regarding a monkeypox outbreak globally, can the Minister indicate whether government intends to institute immediate travel restrictions to countries where the virus has been detected?
Minister of Health.
Yes, thank you very much, Madam President. Good afternoon to you. Good afternoon to members of this honorable chamber. This really falls in the garden of the Minister of Health, so I'll be answering it. Madam President, we at the Ministry of Health took note of the monkeypox outbreak since it started in May 2022. On May 20th, we called a meeting between the Ministry of Health, CARFA, and PAHO, where we alerted the population to the issue. We established a hyperlink so that anyone can go to that and see the countries affected. We also alerted healthcare workers and the public to signs and symptoms. We sensitized the local medical fraternity as to the case definition of monkeypox, the clinical practice guidelines, the protocols for testing, and we put our ports of entry, our port health officers, on high alert with both training of all port health officers. From that time to now, we have given weekly updates. Today, 23rd of June, 2022, I, as Minister of Health, took a note to Cabinet, and the Cabinet approved and confirmed a note where we have added monkeypox to the list of dangerous infectious diseases as we did for COVID. This will allow us to, if necessary, invoke the powers under the Public Health Ordinance and the Quarantine Act to isolate and treat suspected and confirmed cases of monkeypox. In light of these proactive measures and the known epidemiological differences between COVID and monkeypox, inter alia, 1, monkeypox has a much lower rate of spread. In countries where the monkeypox has been detected, the 42 countries, There is no overwhelming of the healthcare systems, as you saw with COVID.
Minister, your time has
Thank you.
expired. Senator Richards.
Thank you, Madam President. Thank you for the response, Minister. Given your response, and including training of port staff and the other measures you indicated, including the cabinet approval, and what we've experienced and learned from COVID, though they be different, can the Minister indicate what other mechanisms may be in place or being considered to protect the population at the ports of entry for monkeypox?
Minister.
Very much. Yes. So as I was saying, because the mode of spread is significantly different, the cabinet note speaks to that. And on all ports of entry, whether they are ports at the airport or seaports, the public health ordinance measures will kick in. Also, as a matter of protocol, whether it's COVID or monkeypox, captains of all vessels, and vessels include seagoing and airgoing vessels, always sign a declaration that there is no infectious disease on board circulating in either their crews or passengers. This is international protocol for all seagoing vessels and also all airlines. And that is what we are doing. We are heightening our response. It is because of this different epidemiological profile where the mode of spread is significantly different. And on June 17, WHO said the risk to the general public is low. Also, it must be noted that the case fatality ratio of this current strain, or this clade, which seems to be the lineage out of the West African clade, has a case fatality ratio of less than 1%. So for those reasons and more, we are not at this time contemplating closure of borders.
Senator Richards.
Can the Minister then indicate, though, as you've indicated, the rate of spread is much lower, minimal compared to COVID, if I can use that phrase, and the death rate may be lower. Has the Ministry of Health prepped the hospital system and hospital healthcare workers in terms of preparation for treatment of monkeypox if and when it should become present in the country?
Minister.
So as I said, on the May 20th, after that meeting we had with Ministry of Health, CARFA and PAHO, I'll repeat, we sensitized the local medical fraternity as to the case definition so they will know what they are looking for. We also trained them on the clinical practice guidelines and protocols for testing, how to take an exudate sample for testing. Also, similar protocols as to their safety with the provision of high-level PPE will be done. So all of that has been done for both physicians and nurses in the private sector and the public sector.
No, that's it. Yeah.
Public business, government business, bills, second reading.
No.
On notice, questions for oral answer.
Acting Leader of Government Business.
Madam President, I'm pleased to say that the government is in a position to answer all three oral questions on the order paper. Thank you.
Senator Mark.
Madam President, before I pose my question, I don't know if you are feeling an extra heat in the chamber. I don't know if the Attorney General has anything to do with it, but there is some heat here, and I am a bit uncomfortable. So I would seek your guidance, Madam President.
Senator Mark, yes, it is it's much warmer than it normally is, but the issue is being addressed. Okay?
Thank you, Madam President.
Senator Mark.
Yes, thanks, Madam President. Yeah, Madam President, question number 114 to the Minister of Education.
Minister of Education.
Thank you, Madam President. Madam President, the Ministry of Education fully understands the concerns parents may have with respect to the health and safety of their children in light of the COVID-19 pandemic. The Ministry of Education is first and foremost guided by the directives, that is, the legal notices of the Ministry of Health, and staff, students, and visitors to school compounds, therefore, have the assurance that all required health and safety protocols, equipment, and resources are in place to mitigate the spread of the virus. Indeed, the data collected weekly show a decrease in the number of COVID-19 cases reported at schools since the full reopening of physical school on April 19, 2022. With the resumption of face-to-face school, as discussed with stakeholders, schools have reverted to the principles that guide the provision of educational material to absent students by principals and teachers. That is, principals will make decisions about this on a case-by-case basis, depending on the circumstances. Illness or unavoidable absence being usual factors which would lead teachers to make the decision to provide educational materials to students not in physical attendance. However, no teacher is mandated at this time to deliver synchronous online sessions to students with the resumption of face-to-face classes. All students are expected to attend school physically unless excused by their principals based on the usual circumstances which guide such excuses.
Senator Mark?
Yes, thank you, Madam President. Madam President, may I ask through you to the Honourable Minister whether the Ministry of Education can share with this Honourable Senate any data relevant or related to students' absences, pupils' absences from school as a result of this reaction, or I wouldn't say reaction, Madam President, but given the initial outrage by parents not to allow their children to participate in these classes, right at the same time when the COVID-19 pandemic was in existence.
Senator Mark, can you crystallize what you're saying into a question, please?
Yeah.
Please.
Madam President, I'm just asking the Honourable Minister whether she can share any data with this Honourable Senate as it relates to students' absences during the period of full resumption of classes given the COVID-19 pandemic and the demand of parents not to participate.
Minister.
Thank you, Madam President. Madam President, the student attendance has averaged from the time of full school reopening has averaged around 70%, and teacher attendance has averaged around 90% for primary and secondary schools. Data is not collected specifically on absence of students based on COVID-19 related matters.
Senator Mark?
Yeah. Honourable Madam President, through you, can the Minister indicate to the Senate whether the attendance of students and pupils normally would have averaged around 70% given the full resumption of school, or is this figure cause for some worry for the Ministry of Education?
Minister.
Thank you, Madam President. The figure is comparable to pre-COVID times, given the reality that there were students, there were teachers, there were staff members who would have been experiencing the COVID virus or would have been in quarantine on the basis of family members and so on, and therefore would have had absences from school.
Senator Mark?
Can I ask the Honourable Minister whether the 70% attendance by students should generate some concern to the Ministry of Education, having regard to the fact that there is a 30%, if I may say so, absence of students at the primary and secondary school at this time, and even in the past. Can you indicate or share with us, Madam President?
Minister.
Thank you, Madam President. Bearing in mind that this is term 3, and therefore the Form 5 students are away from school because they have examinations. The Form 6 students are away from school. The Standard 5 students, on a large basis, also stay away from school during this term, having completed the SE. So as I said, this attendance is comparable to pre-COVID times, taking into consideration also the fact that we are in a pandemic and the fact that there are teachers and students who would be experiencing COVID and quarantine orders and would have to stay away from school at this time.
Yeah.
Thank you, Madam President.
Next question, Senator Mark.
Yes. Question number 115 to the Minister of Education.
Minister of Education.
Thank you, Madam President. Madam President, the Ministry of Education has a well-established student support system staffed by over 300 school social workers and guidance counselors, and they have seen success in treating with students displaying psychological issues such as, but not limited to, fatigue, social isolation, anxiety, and stress. The Ministry, of course, recognizes the importance of addressing mental health issues by utilizing a variety of strategies for providing mental health psychosocial support. At the onset of the pandemic, the Student Support Services Division continued its multidisciplinary approach to student intervention by transforming its processes to an online modality. These systems include referral and critical incident reporting, and the school-based intervention process that leads to the identification of mentally distressed students and the development of individualized intervention strategies as required. Other remote services provided by the Student Support Services Division to support students experiencing varying degrees of mental distress include hotline calling facilities, telemental health support, online mental health support groups, online therapeutic support, and online psychoeducation sessions. Furthermore, the Ministry understands that parental support plays a major role in student recovery, and as such, parents and guardians are sensitized to the ways and means of providing support to their children or charges. This comes in the form of the parenting and education sessions that focus on coping with online learning in a pandemic, positive parenting, dealing with grief and loss, coping and resilience, mental health and your child, understanding and treating with non-suicidal self-injury and suicide, identifying mental health challenges and ways to help your child to cope with anxiety, nurturing children's mental health, substance use and abuse, and depression. It should be noted that these student support services have and will continue to be physically available to all students. Additionally, students participated in a 2-week orientation at the start of the upcoming third term, or the third term that has started now, specifically targeting mental health issues observed during the COVID-19 pandemic. Additional sessions are being conducted during the term. Thank you, Madam Speaker.
Senator Mark.
Madam President, can I ask the Honorable Minister whether the Ministry has conducted any studies on the experiences, psychological, mental, and the symptoms that I've outlined in this question since the resumption of full-time classes. Can the Minister share with us, Madam President?
Thank you, Madam President. This data is collected by the Student Support Services Division in the different schools, yes.
Senator Mark.
The Honourable Minister, whether the Ministry is contemplating or has effected a mechanism to have a small team of your social interventionist unit visit these schools, whether it be primary or secondary, to conduct on-the-spot assessment and evaluation of students since the resumption of full-time classes, having regard to this mental stress and psychological challenges many of them, students, pupils, may have had some experience with during the online experience. Can you share with us whether there's any plan to address that with these teams going on spot?
Minister.
Thank you, Madam President. With very few exceptions, each school has an assigned guidance counselor and school social worker. These are the personnel that would do the interventions that are necessary after doing the needs assessments with the students. Students can also be referred, who may not present with any issues, may be referred by their parents or the student themselves, or their teachers may refer them to the student support services officers. So in this way, all students that are presenting with issues are dealt with by the staff of the Student Support Services Division.
Senator Mark.
I ask the Honourable Minister, through you, Madam President, whether the Ministry has received any reports concerning students and or pupils rather, who would have had some challenges in learning upon their resumption of full-time classes, having regard to the experiences that they would have suffered, or at least, well, experience, I don't want to repeat that word, but experiences that they may have had during the online period at home. Have the Ministry been able to get any reports on any dip, any gap in the learnings of children as a result of that experience?
Senator Mark, I won't allow that question.
Okay. Thank you very much, Madam President.
Yeah. Next question.
Can I ask it one time?
Just one, yeah.
Question number 116 to the Minister of Public Utilities.
Minister of Public Utilities.
Thank you very much, Madam President. Madam President, the circumstances that led to a disruption in the water supply in 2 streets in East Port-of-Spain in January and February of this year was as a result of a defective distribution line, a burst distribution line, and a defective valve. I'm advised by the Water and Sewage Authority. As a result of that, a technical team was dispatched to the area, and a pressure testing was successfully completed. The valve was replaced, and the line was repaired, and the water supply was immediately restored to the community.
Senator Mark.
Can I ask, through you, to the Minister, Minister, could you tell us, Honourable Senate, how long the process that you have outlined took?
Minister.
Madam President, the matter was brought to the attention of the authority. The technical team was immediately dispatched, and before the end of the day in question, the water was restored to the affected community.
Senator Mark.
Well, I'm happy about that, Madam President, for the people of East Port-of-Spain. Thank you very much. Madam President, before I leave again, I'm very uncomfortable. It's becoming unbearable. I would ask you to consider suspending the Parliament so that whatever is being addressed could be addressed, so that we do not sweat or feel, to faint in this heat that is emerging. Thank you.
So, honorable members, the situation has been addressed, and within about 20 minutes, we are going to feel the difference, okay? So I'll ask everyone to, yeah. Honorable Senators, I will now revert to the earlier item on the order paper. I am now in receipt of the following correspondence from Her Excellency the President, Paula Mae Weeks, ORTT. The Constitution of the Republic of Trinidad and Tobago by Her Excellency Paula Mae Weeks, ORTT, President of the Republic of Trinidad and Tobago and Commander-in-Chief of the Armed Forces. To Mr. Michael Seals. Whereas Senator the Honorable Alison West is incapable of performing her duties as a senator by reason of her absence from Trinidad and Tobago. Now, therefore, I, Paula Mae Weeks, President as aforesaid, in exercise of the power vested in me by Section 44(1)(a) and Section 44(4)(a) of the Constitution of the Republic of Trinidad and Tobago, acting in accordance with the advice of the Acting Prime Minister, do hereby appoint you, Michael Seals, to be a member of the Senate temporarily, with effect from the 23rd of June 2022, and continuing during the absence from Trinidad and Tobago of Senator the Honorable Alison West. Given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the Office of the President St. Anne's this 23rd day of June 2022. Honorable Senators, the Senator is required to take the oath.
I, Michael Seals, having been appointed a Member of Parliament, do swear by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
Public business, government business, bills, second reading.
Attorney General. Members are free to leave the chamber, but you must do so in silence. You must do so in silence.
Thank you, Madam President. I beg to move that a bill entitled An Act to Amend the Sexual Offences Act, Chapter 1128, and for other related matters be now read a second time. Madam President, today I have the privilege to pilot in the Senate, this August House, the bill entitled the Sexual Offences Amendment Number 2 Bill 2021. This bill was passed in the House of Representatives on May 6, 2022. The bill received the full support of the opposition as it was passed with 33 votes in favor, 0 against, and 0 abstentions. This bill amends the Sexual Offences Act 1986, which has gone through a total of 3 amendments from 2000 to the present. The Sexual Offences Amendment Act 2000 amended the 1986 Act by, among other things, inserting a new Part 3, notification requirements for sex offenders. That 2000 amendment was subsequently assented to on September 25, 2000. Regrettably, the intent and purpose of that 2000 amendment was not realized. Once assented, difficulty in the implementation of Section 34B soon became apparent, as a convicted person who was required to report to the police station within 14 days of his or her conviction, during which time the convicted person would be incarcerated and serving his or her sentence. Thus, this requirement under the law was impracticable. Needless to say, since this legislative incongruity, there has been no adjustment nor amendment to the system for the registration and reporting of sex offenders in Trinidad and Tobago until now. Madam President, significant amendments were made in 2019 to ensure a workable system of registration and reporting. The opportunity was taken then to also amend other areas of the Act, which included harmonizing the age of liability for the commission of a sexual offense under this Act with the age as stated in the Children Act and the Trafficking in Persons Act. Further amendments were made in 2021, and the Sexual Offences Amendment Act 2021 was proclaimed on August 18, 2021. The Act was amended to distinguish 1, the Sex Offenders Registry, meant for the Trinidad and Tobago Police Service's sole use, to be known as the National Sex Offender Register, and the Sex Offender website for public access, which would maintain limited information on sex offenders for the public's use, to be known as the Public Sex Offenders website. The Act specifically provides timelines for when a person must be placed on the website, whilst taking into account a person's right of appeal and preserving due process by providing that the convicted sex offender may apply to the court to show cause why the person should be exempt from registering or reporting. Madam President, we are assembled today to discuss further amendments to 3 sections of the Sexual Offences Act as amended, specifically sections 48, 56, and 57. I wish to now go through the relevant sections of the proposed amendments and the proposed amendments to each. The relevant sections, Madam President, of the proposed amendments to each would be addressed by me as I continue. Madam President, apart from the proposed amendments to the aforementioned sections, I wish to give further information on issues that were raised by several colleagues at the House of Representatives and to provide clarity on those issues. Issues raised throughout the debate: population of the register. The issue was raised in the other House that the register is not operating as it ought to be operating at the moment. At the outset, it must be recognized that the Public Sex Offender Register website, is to be distinguished from the National Sex Offender Register, the latter being for law enforcement use only. Section 47(1) of the Act clearly states that the National Sex Offender Register is not open to the public. Correspondence submitted to the Trinidad and Tobago Police Service dated March 25, 2022 and received by the Office of the Attorney General indicates that this national register is fully populated with the details of sex offenders for the year 2000 upwards to the present time. There is a station sex offenders register located at each police station and an e-register, which is the central repository of all information on sex offenders maintained by the Trinidad and Tobago Police Service Criminal Records Office, the CRO. On the other hand, the Public Sex Offender website, which is accessible to the public, applies prospectively. The Trinidad and Tobago Police Service must await convictions and information from the register in order to publish this information on the website. I wish to remind this House that under Section 48(2) of the Act, the information regarding a registered sex offender shall not be published on the public website pending the determination of an application for exemption or an appeal, and until the Commissioner of Police receives an order from the registrar. Further, the Trinidad and Tobago Police Service's standard operating procedures on the National Sex Offender Register and the Public Sex Offender website are outlined under the Trinidad and Tobago Police Service Departmental Order number 1 of 2018. This departmental order provides a comprehensive guide to sensitize police officers on the operationalization of the law relating to sex offender registers and the procedures to be adhered to when officers are required to populate and access these registers.
Attorney General, I think Senator Sipasad is asking if you'd give we.
Certainly, most certainly,
yes.
Madam
Senator
President.
Sipasad.
Thank you, AG. AG, I understand a sex offences registry is still a work in progress, as you're saying. My concern is the public website, sexoffenders.gov.tt. The information there, because I went and checked, is non-existent. The drop-down menu has 3 areas, Arima, Curep, and Port of Spain, and they don't work, as well as the searches by name. And it's not user-friendly, and it comes up saying...
Senator Sipasad.
Yeah, I'm giving the question now.
Oh, thank you.
The connection is not safe. AG, I would like to know when the public can expect to have a working online system that is populated in the time frames that you are going to specify, etc. Thank you.
With your leave, Madam President, thank you very much for that question, Senator. It is certainly a relevant question that targets relevant concerns. As I'm piloting the bill this afternoon, you would appreciate that with the best will in the world, I couldn't immediately address that question by way of answering it. I will make the relevant inquiries, and I certainly give the assurance that in the shortest possible time, I shall be able to assist in answering that question. Thank you. May I continue, Madam President? Thank you very much. I was saying that the Trinidad and Tobago Police Service Departmental Order number 81 of 2080 outlines matters which are included. So we have, for instance, the creation of the station sex offenders registers and corresponding acknowledgement receipt books to provide receipts to offenders upon notification, the creation of an e-register to electronically store information concerning all convicted sex offenders to be maintained by the CRO, the notification requirements for sex offenders inclusive of timelines mandated under the law and the penalties for failure to comply, the administrative duties of the second division officer in charge, the IT department, and the CRO, the Trinidad and Tobago Police Service's duty of confidentiality and repercussions for breach of same, which are very important, respecting the privacy even of convicted persons, the procedure to be adopted where sex offender breaches notification requirements and guidelines on the use of the registers. The TTPS, therefore, has sufficient mechanisms in place for the implementation and effective functioning of the National Sex Offender Register and the Public Sex Offender website. And I pause there to emphasize in answer to your question, Senator Sipasad, that of course the question that you've asked is relevant and will be investigated. The TTPS remains cognizant of the mandates prescribed under the legislation and the caveats stipulated by law in relation to the publication of information on the website. A question may arise whether the Act is constitutionally valid, and of course, in determining that question, the issue of proportionality and sound research will have to be examined if ever that question had to be examined and answered. And it is my assurance to the population that the issue of whether the Act is constitutionally sound is certainly unanswerable. It was determined, Madam President, in making these amendments that a balance must be struck between information given to the public and the sex offender's right to privacy in order to prevent victimization of the offender and vigilante justice. And various decisions of the Supreme Court and of the courts of the Caribbean, Commonwealth Caribbean have been looked at, not least among being the decision of Huang and the Secretary of State De Freitas and the Permanent Secretary and Ministry of Agriculture, Fisheries, Lands and Housing coming out of Antigua and Barbuda. And I dare say we are reassured today as we stand here that the very decision of De Freitas and the Permanent Secretary of the Ministry of Agriculture coming out of Antigua and Barbuda, which was at its time the locus classicus on the test of proportionality under Section 13 of our Constitution, has now been very recently revisited, and the current locus classicus, which I dare say exists for the entire Commonwealth, is the case out of Trinidad and Tobago, reported only on Monday, the case of Suraj and Maharaj and the Attorney General of Trinidad and Tobago, which I commend to all legislators. In this regard, Madam President, the government has determined that the society's protection from sex offenders is sufficiently important to justify limiting the sex offender's right to privacy. The public sex offender website is designed to give public access to specific information regarding the sex offender in order to identify him and be aware of the locality in which he resides. This information is necessary to meet the legislative objective of protecting the vulnerable in our society from such predators. And we therefore submit that the law is balanced and constitutionally sound, proportionate, and meets the test laid down as recently as Monday, the 20th of June, in the Suraj decision. Additionally, as previously stated, based on further research, Madam President, the following jurisdictions have public access websites that offer extensive details on sex offenders: the United States of America, South Korea, Canada, Nigeria, Poland, and the Maldives. Clause 4 of the term, if we were to look at Clause 4 immediately of the bill before this August House. Clause 4 takes us immediately, Madam President, to Section 48 of the Act and provides in subsection 1, in subsection 4A1, by inserting the words sex and before the word photograph, and B, by inserting after subsection 7 the following new subsection, where, that is to say, subsection 8, where there is a change in the information published on the website in relation to a sex offender or registered sex offender, the Commissioner of Police shall, without delay, update the information on the website in relation to that sex offender or registered sex offender. My colleagues on the other side raised the issue that the use of the term without delay under Clause 4 is vague in construction and does not bring clarity to the legislation. Madam President, I have already addressed this issue in my closing remarks in the other place. I wish to reiterate, nevertheless, and to amplify my response. The amendment at Clause 4, which proposes to amend Section 48 by adding a new subsection 8, requires the Commissioner of Police to update the information on the website without delay. This term is introduced by the prefatory word shall in the amendment, and those of us who are familiar with the English language and the language of the law will understand immediately that the introduction of the words without delay, preceded by the prefatory word shall, introduces an imperative. Further, Section 23 of the Interpretation Act states that where a written law requires or authorizes something to be done, but does not prescribe the time within it which it shall or may be done, the law shall be construed as requiring or authorizing the thing to be done without unreasonable delay, having regard to the circumstances and as often as due occasion arises, unquote. Taken in its context, therefore, it means that the term, the composite term, shall without delay, that is to say, you read the three words together as opposed to dysfunctionally separating them, shall without delay imposes an obligation upon the Commissioner of Police with the understanding that it must be done without unreasonable delay. Therefore, there is no lack of clarity in the language in doing that which the amendment empowers him to do. The Commissioner further can only act once information is received, and this must be factored into in the context of what constitutes unreasonable delay. My colleagues in the other House further stated that the timeline of without delay places a burden on the Trinidad and Tobago Police Service. It must be appreciated that the timelines placed in the bill are important for the effective functioning of the registers. The Commissioner of Police has responsibility under Section 48, subsection 3, of ensuring that the website is maintained, and I give that assurance to my colleague on the independent bench, Senator C. Prasad, that the website must be maintained and the information recorded in accordance with the Act. In this regard, the Honorable Member of San Fernando West and former Attorney General also responded to that issue by rightfully pointing out that this is a sword that has two edges. The timelines not only ensure TTPS compliance, they also ensure that victims have the right to demand that the TTPS acts appropriately. Madam President, inclusion of more information. The members of the other House also raised the issue of whether the information contained under Schedule 3 of the Act should not be well known to all and sundry. It was also questioned whether there is a need to provide more information to the public than the Act provides, notwithstanding the conservative approach taken in the textbooks on the subject. Madam President, the provisions allow parents, guardians, and caregivers to formally ask the police for information regarding a person in close contact with the child if they are concerned that close contact with that person poses a risk to the child. The presumption to disclose only exists where the person has convictions for child sexual offenses and the disclosure is strictly confidential. Section 48(4) of the Act specifies the information to be published on the website for the public's access. This includes the sex offender's name, former name and aliases, date of birth, photograph, locality in which he resides, and convictions of registrable offenses committed by the offender, including the date of each conviction. Clause 4 of the bill proposes to add the sex of the offender to this list of specified information. In drafting the amendments in 2021, other jurisdictions which provide for public sex offender websites were examined, and I list those other jurisdictions without going into the details of the actual provisions made. We examined the United States of America, the Republic of the Maldives, Nigeria, Poland, South Korea. Madam President, we also examined Canada and the United Kingdom. Madam President, having regard to the detailed information that is accessible to the public in those jurisdictions, the challenge existed for this government to be not only cognizant that there is precedent for including additional details of the sex offender, such as his or her full address, but also to strike an appropriate balance. We opted not to go into the detail and to go quite as far as the other jurisdictions have done. We included what we considered to be digestible for our society in the first instance. This is a novel matter being introduced for the people of Trinidad and Tobago, and we therefore think it prudent to begin in small steps. The government is mindful that depending on the effectiveness of the public access website, we may return to Parliament in the future to expand the details available to the public regarding sex offenders. And of course, we have to make sure that the sex offenders website is functional, properly updated, and working properly. Again, I take the opportunity, Madam President, to remind this Honourable House that there is a clear distinction between the information published on the National Sex Offenders Register and the public sex offender website. Whilst the information on the website is general, the information contained in the National Sex Offender Register is far more detailed and includes intimate information, such as the offender's DNA. This information on the National Register remains accessible only to law enforcement and not to the general public. This information is necessary to further any ongoing investigations by the Trinidad and Tobago Police Service. Clause 4, the inclusion of the word sex and notification to members of the public. And that was introduced. The members will see Clause 4, Section 48 of the Act A, in Section 48, in subsection 4A3 by inserting the word sex and before the word photograph. Members of the other House also raised the issue that this amendment under Clause 4, which proposes the addition of the word sex before the word photography, is reflective of sloppy work on the part of the government, and a number of concerns were raised. As I mentioned in the other House, we are here today to improve on a continuing and vigilant basis the legislation that it is our privilege to bring to this House to improve the conditions and to protect the vulnerable. So it is not sloppy work. It is an encouraging on our part of the vigilance which we must continually undertake and on the part of all parliamentarians. And we welcome contributions, positive, constructive contributions from all members of Parliament to ensure that as we work towards bettering the society for our citizenry, we continue to keep our work under review to improve at every step of the way. As it relates to the locality of the offender, I must reiterate, while several jurisdictions have adopted this approach, for example, the US has one of the most comprehensive listings of sex offender registers in the form of the National Sex Offender Public website published in the United States Department of Justice, and that information published for each offender includes his name, her name, full address, geographical location, aliases, age, and photograph. In addition, in Canada, in certain provinces, as mentioned earlier, the public has access to photographs, aliases, addresses, background information on the offender, details of all sex-related crimes for which the offender has or is being convicted, date of release, and prohibitions imposed on the offender by the court. The government understands, Madam President, the fears of members of vigilante justice, but a balance has to be struck between information given to the public and the sex offender's right to privacy. And it is in this regard that the government has opted to provide legislatively for the sex offender's website, which is available to the public in the terms that is designed. Madam President, I've taken the time to address the concerns raised by members of the House of Representatives in order to ensure there is no lacuna in the legislation. The proposed legislation specifically provides timelines for when a person must be placed on the website, whilst acknowledging that person's due process right of appeal and his right to make an application to be exempt from the register. The proposed amendments also provide for some clarification. The purpose of this bill is consistent with our responsibility of continued vigilance and due diligence in relation to the improved efficacy of the legislation. So if I just draw members' attention briefly to those other sections which are to be amended, I've already dealt with Clause 4. Of course, Clause 3 refers to the Act, meaning the Sexual Offences Act. Clause 5, Section 56, I read of the Act, is amended in subsection 2 by deleting the word offence and substituting the word sentence. And Clause 6, I read, Section 57 of the Act is amended A in subsection 3 by deleting paragraph C and substituting the following paragraph. And the substituted paragraph C will read, within 7 days of the receipt of the information, verify that the information provided by the registered sex offender is correct before he enters it into the register. In subsection 4, in paragraph A, by deleting the word receipt and substituting the word verification, and Roman 2, by deleting paragraph B and substituting the following paragraph. B, within 3 days of recording the change, forward the information to the Commissioner of Police, who shall, without delay, update the information on the website referred to in Section 48. Madam President, I beg to move.
Honourable Senators, I shall now propose the question for debate. The question is that a bill entitled An Act to Amend the Sexual Offences Act, Chapter 11, 28, and for other related matters be now read a second time. Senator Lutchmedial.
Thank you, Madam President, for the opportunity to contribute today to this debate. Madam President, I want to start off by saying that whilst the bill is very short, we do know that the establishment of what is a public sex offenders website is something that raises a lot of concern within the population, and therefore we shouldn't treat lightly with any amendment being made, because at the end of the day, even convicted offenders have rights, and we have to ensure that whatever we do when we are dealing with this bill, with this piece of legislation, that we have a balancing of the rights. And we also want to ensure, as I heard the Attorney General say, that we do not have vigilante justice taking place at this point in time. But, Madam President, more important to me, because I'm not so concerned about that given the state of affairs and what we're seeing happening around the country, but I'm more concerned about the ability of the persons who have specific duties under this law to carry out those duties. And I would get to that in a short while. So the history of this law really started in 2019, as we've heard, when the concept of the National Sex Offenders Registry came into being, and it was introduced by way of a substantial amendment to the Sexual Offences Act. There was a special select committee, I think, of the Senate to consider that particular bill, which predates me, but some of my colleagues sat on it, and I know that the idea of a public sex offenders registry was the subject of a lot of debates and consultation. And I believe that coming out of those consultations, there was, because of the small society in which we live, it didn't seem prudent at the time to have a public element to that sex offences registry. And I don't want to go through all of the contributions made and these different persons. As you may hear later about the other special select committee, which Senator Richards and I sat on, you had very extensive and powerful contributions coming from civil society organizations when it comes to issues like this. And of course, it's our duty to consider all of them. So I believe there's still a lot of uneasiness surrounding a public sex offenders registry, but the simple fact is this: crimes of a sexual nature seem to just be exploding, and they are all around us. And so when it comes to being able to, for example, the most topical example that can come to my head right now, verify the types of offenses that persons you are employing in places where they are close to children. Perhaps a public offenders registry or website is necessary if it would assist in ensuring that the types of persons we employ in these places are not persons who might have been previously convicted of, heinous crimes of a sexual nature. I want to say that the provision seems to be more of a tidying up nature for the efficient running of the registry, the public registry. So we want to ensure the information is up to date. You want to ensure that the information is actually verified. And of course, anybody who has ever worked in the criminal justice system knows how important that is and how much we have sort of fallen behind in that respect. So as recently as I think it was last year, I recall a matter involving a person who was issued a fixed penalty ticket and paid it, and it was never recorded on the system. And some 3 years later, he was arrested and, ended up suing the state, of course, and the taxpayer having to foot the bill. The name of the case, I believe, was Patrick Awong. It's a judgment reported, and Justice Sipasad was the judge. And, I remember Justice Sipasad in his judgment speaking extensively to the breakdown of the state's machinery and a total lack of communication between the judiciary and the TTPS. And that is what resulted in this man being arrested, held at a police station on a warrant. I, too, have had circumstances where cases like that have come across my desk, where persons are being arrested on warrants for things that have, missing court dates, for example, when the matter was actually dismissed by the court and a warrant being issued for their arrest. I've had cases where I've had to send letters. It never got to the stage of litigation, but I've had to send pre-action protocol letters to the TTPS threatening to sue because every time a client went to get a certificate of character, it was showing matters pending against them which had been dismissed some 5-6 years before, or for which the person had been found not guilty. Because the process in the TTPS, actually, from what my understanding, and I would stand to be corrected if this has changed, but my understanding has always been that when a person is convicted or acquitted, it is the duty of the complainant to now inform the Criminal Records Office, and that Criminal Records Office has to put things in place. And I think the Attorney General did say that the Public Sex Offenders Registry is being operated by the Criminal Records Office of the TTPS. So I mean, I am all fed up here myself talk about resourcing for things to work in the criminal justice system, because I feel like I am always talking about that. But I feel like I have to make these specific examples known, and it is there. It is out there where people. I don't think the case that I referred to of Mr. Awang is a case in isolation. There have been other cases where things have been done. Warrants and so on, people being arrested, not missing court dates, just for the absence of updating records. So this brings me to the point of the updating that we are doing and the amendment that we are making to Section 48 and the without delay. Now, the Attorney General is right in terms of Section 23 of the Interpretation Act deals with situations where there's not a specified timeline. But I just want to say that it would have given me a lot of comfort if the police had a timeline here. Me as a member of the public, not me as a lawyer or a litigant or whatever, but I would have liked to have some sort of a timeline, because I feel like that is the only way to get things moving sometimes in this country, if there's a definitive timeline. I remember there was a case where, usually cases of delay in administrative law, it has to do with delays in decision-making or delays in the claimant coming before the court. But the principles are sort of the same. But there was one case that I found where there was a delay, and I remember the case. There was delay in the Defense Council, which is part of the Defense Force, it's set up under the Defense Force Act, in meeting to determine an application. I think the person's name, the soldier's name in that case was Andrew Thompson-Ahye. And in that case of Andrew Thompson-Ahye, Justice... Justice Basad, again, totally coincidental, set out some of the factors that you would have to consider when you are thinking about whether or not a delay on the part of the state to do something when there's a statutory obligation to do it would then, of course, result. I think that in that case they were thinking whether or not it resulted in an infraction or an incursion on the right to protection of the law. Because as we all know from cases like the Maya Leaders Alliance case and all of that, protection of the law is a very wide concept, and the courts can interpret it as though the failure of the state to do something when there is a positive duty to act in a case such as here, whether or not that can somehow be an infringement of anybody's right to protection of the law. So in this case, you're looking at the victim. If there's not a timely updating of this website, and the delay on the part of the police in doing so has to be determined by the court. What are the factors they're going to look at? Well, one of the factors they look at is the importance of the matter. They look at the resourcing and the amount of matters that the police or whichever agency it is responsible, the amount of matters they have under their consideration. And there are a host of other issues that you would have to consider. But in this case, you have as well, what if the court orders that even though the matter is on appeal, that the person, because of maybe the severity of the matter and all of that, it still has to be placed on the website. And then that appeal is determined in favor of the defendant. And it takes, who is to say what is the period of time that will be acceptable if I am acquitted of an offense to remove my name, my photograph? This is not simple information. This is very detailed information. In a small society, it is absolutely very easy to identify anyone from this information that is going on this public website. So what is the time frame within which I, as a defendant, would have the right to come to the court and sue for the failure of the police to act? Because if the commissioner of police, who has control over this public website, is depending on the prosecutor in the matter, or the police prosecutor, or the complainant in the matter, to send the matter up through the channels, well, I'm very fearful that the updating of this website might actually fall the way of what we see here happening with fixed penalty notices and other things, that the delay can be so unacceptable and so great that it can have consequences for persons acting there. So I flag that simply to say this, that the operation, this is not like a traffic ticket that you don't pay and you get arrested on a warrant. This can have serious, far-reaching effects on the lives of the individuals who are placed there. And if the the delay is so egregious that it causes some sort of impact on either the victim, on other persons. What if, for example, I had a policy at my place of business that I would scan my employees against the Public Sex Offenders Registry because I have children at my place. I'm running a daycare center, and so I must scan them. And the police have failed to update that website in a manner that was, efficient and prompt. And their lack of promptitude, prevented me from being able to know that this person who was screening for a position in my particular place of employment or my business was, in fact, a sex offender. Am I then going to be responsible? Who is responsible? There's a host of things. And that's where, when you have citizens dependent on the state to do certain things, I like timelines. So I don't know if the Attorney General will be willing to consider that a reasonable timeline be given here, to ask for the Commissioner of Police to, have the information updated, even if it says that within 14 days of the notification, within 14 days of the event, something like that, to just make sure that it is not, in fact, then just falling by the wayside and waiting for somebody to do something. I remember when I was reading this that we were debating 2 bills on the creation of companies to run SAPA and NAPA. And no person other than the Minister of Tourism stood here in this parliament and complained about the length of time things take to move from one desk to the other within his own ministry. That sometimes people would then ask to utilize the facilities and so on, and it would take so long that the date of the event would pass and it wouldn't even reach the proper desk that it needed for approval. So I'm not making things up. The other side are very well aware of the delays that plague public service, that plague TTPS, that plague many different areas, and the bureaucracy, and the fact that we are still very much paper-based in some of these things. And I know that the efforts are being made to get there, but I'm in Magistrates Court more often than I would like, and I know that they are still grappling with getting the official TTPS email to work properly so that they could complete disclosure in a trial. They have challenges with those things right now. I'm getting emails for disclosure. When the court orders disclosure, I'm getting all kind of Gmail, I'm getting WhatsApp and things like that in very informal channels because their email servers and so on are always going down and are not working properly and things of that manner. So you have to creep before you can walk sometimes, and certainly before you can run. And sorting out these minor details, but putting in place consequences or timelines for things to get done might actually help to drive the thing in the right direction. The other thing that I wanted to talk about, Madam President, is that the impact that a public sex offenders registry will have on what is really a serious societal problem that we face right now is simply dependent on us having names to put on the register. And the name's not going to get there on the register unless we have improved detection and conviction, because it is only upon conviction. I know that the former Attorney General, Minister of Rural Development, had said on the last time last year when we were debating an amendment to the same bill that if he had his way, we would have even persons who are accused and charged before the court on a public register. I have very strong views on that, of course, because I think that violates the presumption of innocence. But the fact is that we have a low detection rate, but we have an even lower conviction rate in this country. And until we feel, or until we move towards a place where, particularly for sexual offenses, that we are convicting people on solid scientific evidence, we are not going to raise our detection rate. We are certainly not going to raise our prosecution rate, because our conviction, detection and conviction rates, because a vast majority of sexual offense crimes right now in this country simply depends on the word of a witness versus, who is oftentimes a victim. And many times, there's nothing more horrific, and I could tell you there's nothing worse in this world than having to take evidence from a child victim of a sexual offense. And I've done many of those matters. And there's nothing worse than that. But the evidence is often so understandably shaky sometimes. That is very difficult to get a conviction. So this registry, we need warm bodies to be in the prison. We need warm bodies, actual people. It sounds nice that we have a registry, and I'm happy. I did the same thing that Senator Sipasa did in checking it, and I said, well, I've seen 3 locations, and I've not seen anything else, and clicking. I thought it was me, to be honest with you, so I'm happy somebody else had the problem. But no matter how fancy the registry and the website is, and how many pieces of law we pass to add and take off, the different types of information that we want to put there, if we're not convicting people, it's not going to have anybody there to put. So sexual offenses is one of those areas specifically where the detection and conviction rate could be increased significantly if we had more emphasis on scientific forms of evidence, DNA, fluids, etc. I asked a question in this parliament some months ago. Can't recall if it was this year or last year, but I remember it was former Senator Ramrat who had responded. And in total, there were some 16,000 samples awaiting testing at the Forensic Sciences Center. That is what it boiled down to, in different categories and so on. But a substantial amount, I recall, had to do with, fluids. When we take fluids from people, those are the things that you need to be testing in order to convict people and put them on this register. So that when they go for a job, or they're joining an NGO where they will be interacting with young children, or when they are applying for a taxi driver's badge license, although we know a lot of the types of offenses, sexual offenses that are reported don't have to do with registered persons, but rather the unregistered types, and those are other issues that have to be addressed. But still, any type of job where a person may wish to screen you, it really depends on the efficient working of our criminal justice system in detections and prosecutions. So we have to address that. I want to say that I was very, very troubled. Well, a couple of things on this matter troubled me. One is that a task force committee set up to investigate crimes against children in children's homes took about 5 months to be laid in the parliament. Thereafter, after much public uproar and many front-page stories about the horrendous events taking place amongst our most, I would say perhaps our most vulnerable population when you look at children, because these children, there's a reason why in the law they are called children in need of care and protection, because that's exactly what they are.
Lutchmedial, if I may, I've been listening very carefully, and you need to link up what you're saying. I gave you a lot of leeway before with your previous point, and I just want you, please, to remember what we are debating.
Yes, Madam President. And so we are debating whether or not we want to make amendments to a public sex offenders registry, and I'm still on the point of actually being able to find the names to get onto the registry. When we have delays such as those things in terms of treating with issues of persons and locations and situations where we have sex crimes being committed, and the police are saying that they are awaiting the reports to come from the adults in the home, I have to wonder whether it makes any sense to have a public sex offenders registry. Because that, in my respectful view, defeats
So, Senator Lutchmedial, I hear you, but this is not about this bill is not about the entire criminal justice system. It is a very specific bill. And while I have given you the leeway, I will ask you now to sort of come to the bill, please, okay?
Now, again, the point of having a public sex offenders registry is being able to find people. Now, if we have to go to clause 6 and section 57 specifically, to say that within 7 days of the receipt of the information provided, the TTPS must verify. I made the same point as before. There is a penalty, of course, imposed on the offender by way of the parent legislation for not providing the information on any sort of change. But some of the information, I would say, is very difficult to verify. Some of the information they have to provide, for example, is the next of kin. How do you define your next of kin if you're living in a house with numerous people. If the next of kin dies and you fail to inform the police, do the police, or you just change the next of kin for whatever reason, or your email address, all of those things, they're there's a lot of nitty-gritty details. So there's a penalty being imposed on the offender for failing to come to the police station and make the relevant notification. However, again, what does it entail for verification? How do they verify? And then we are setting a time frame here for verification, which could take, could take on a number of different forms. So that in subsection 3, where we've deleted subsection 3, we say within 7 days of receipt of the information, verify that the information provided by the registered sex offender is correct before he enters it into the register. And then the amendment now to the register moves from not receipt but to verification. Well, what if they cannot verify within 7 days? Then, of course, I guess the law will have to be interpreted that it happens when it is verified. But do we have resourcing? Do we have capabilities? And at what level does the police officer have to be satisfied as to the verification? What if they cannot verify it? What if some of the information provided by the particular offender simply turns out they cannot verify? What then? What is the process to be triggered then? Is the person to be charged for failing or for providing false information? Because it is actually possible for someone to masquerade themselves by providing false information under this bill. So I think that the actual logistics here could use a little bit of perhaps tidying up. Perhaps it is that it has to play itself out for some time and we see how it works. But then again, we have other timelines here. Within 3 days of the recording of the change, forward the information to the Commissioner of Police to update the information on the website. Now, why do we have a timeline here, but we don't have one in section 48? And I find that that's, a bit strange, where we would rely on without delay, but then we will go down to section 57 and we will fix some very stringent guidelines. And I don't know if the Attorney General could give us the reasoning behind that. So, Madam President, at the end of the day, as I just wind up, I would say that a public offenders registry is something that we decided as a population was necessary. We have attempted as best as we could to craft legislation that would balance rights. There are serious concerns still, as I said, coming out of the Special Select Committee on the Sexual Offences Bill 2019 about the impact on a small society such as this, and getting these timelines and these actions right and making sure that it can actually be done is certainly, in my view, a significant part of ensuring that it works in such a way that no one is prejudiced, not the victim, not the offender, not the public at large, who will be depending on the public offenders registry. And finally, as I said before, without the resources to actually convict people, detect and convict people, well, I don't know that. I think this website might end up in the state that remain in the state that it is right now, because it sounds simple enough to have a website, but the actual logistics behind getting the website running and working, as has been pointed out today, is not something that is actually so simple, and it requires some attention if this is to have any meaningful impact on our population. And I think that those are the points that I wish to make today, Madam President. Thank you.
Senator Richards.
Good afternoon again, colleagues. Thank you, Madam President, for the opportunity to contribute to this important bill. There are several names that I can call to justify both a national sex offender register and a public register, a public website, sorry. But I'll just call one. And this one name will justify, particularly to me, the existence and maintenance of a public website. Akil Chambers. Akil Chambers. And that name should scare us all because of what happened to that child. And the fact that to date, justice has not been found for that child. And that child is gone, and his parents and friends and this country have not seen the perpetrators brought to life. And whoever that perpetrator is, or those perpetrators are, because there are suggestions that it may have been more than one person, their names should be available to the public so that other children and families can be protected and be aware of who they are, where they are, so that more vigilance can take place where people protecting their children are concerned. And I fully understand the conversation about the rights of a person and their privacy, even persons who are convicted of crimes. But to me, the protection of citizens, in particular children, much far outweigh the rights of a person who has gone through the judicial system, has been given a fair trial, the right of appeal, and has been found guilty of that crime, that type of crime. And I make no apology for that. This bill, as the Attorney General and Senator Lutchmedial indicated, seems short, but there are some serious implications to several parts of it. And as the Attorney General indicated, 33 voted in favor, none against, which means as a parliament, we realize the importance of these kinds of steps, these kinds of laws in protecting citizens, in particular children, from heinous crimes, sexual abuse in Trinidad and Tobago. And there's a long list of, unfortunately, long list of names of children who have been abused and for whom justice has not been found. And Senator Lutchmedial is right, because the issue of gathering evidence and doing the work to bring these perpetrators to justice is not where it should be in Trinidad and Tobago. But that also does not mean that we should not take steps and do what we need to do as a parliament to ensure that the protections are in place if and when those persons are brought to justice. Madam President, the causes I want to focus on are Clause 5, Section 56. And I understand, because I was part of the Special Select Committee that Senator Lutchmedial spoke about, that produced the report. And there was quite a bit of conversation about some of the issues related to a national sex registry one, and more so the website, because of the implications in particularly a small jurisdiction like Trinidad and Tobago. Because we are a really small country where, while everyone will understand, and in subsection 4, Section 57 amended, there's of course the proposal, the provision for the registered sex offenders to include name, former aliases, date of birth, photograph, locality, etc. In terms of the public website, I think it's extremely important, and I know the point has been raised before, but I think the point is so germane, and if one does any of the research in any of the jurisdictions around the world, the issue of that issue of vigilante justice, not only on behalf or targeting the accused and not the accused, the person convicted, the convicted, but also members of their family, and the stigmatization of the family home, and in some cases the entire area is a real concern. Because imagine for a moment that more than one convicted sex offender is attached to a particular village or town in Trinidad and Tobago. And what happens to other persons living in that jurisdiction or in that area? Because we're a small country and it's very easy to imagine that we get to the point where we find a particular area being called sex abuse town. So we have to be careful and guard against those types of instances where localities are concerned in Trinidad and Tobago. Because it's not only the convicted person who may end up being the subject of being targeted by vigilante groups, or the family of that person being the subject of taunts and threats in that area. And we also must have a vigilant response to any kind of vigilante overtures in a particular area, and that's where the work of the Trinidad Tobago Police Service comes in. So in that clause 5, section 56, I think we need to be very careful of the issue of locality. Now, in subsection 4A, and there's a lot has been spoken about 57, clause 57, section 57, and the issue of the compliance of the police officers or the police service, the person designated so to do, in 7 days. And through you, Madam President, what are the repercussions of non-compliance? So there are several provisions for compliance on behalf of the Trinidad and Tobago Police Service. What about persons who breach the confidentiality issues? Because we know we have runaway horses inside the police service who may seek to use their position in office and in some instances access to do dastardly acts. What are the penalties for those? And I know the schedule and regulations may account for those. This police service has inbuilt regulations and disciplinary measures. But given the gravity of the possible breaches here and the implications to the breaches, what are the penalties for non-compliance? What is the penalty for the police not acting without delay, as specifically stated here? What is the penalty for the police interpreting without delay to be 3 days? And yes, the Honorable Attorney General said, shall without delay. You and I and all of us have an interpretation. Well, that should be within the next hour or 2 hours or 3 hours, certainly within the next 12 hours. What happens if it goes for 2 days, 4 days, 7 days? What is the repercussion from the TT Police Service? And who is going to hold the officer or the police service as a whole accountable for that breach or that non-compliance? Who or what? The Parliament, the Police Complaints Authority, the Professional Standards Bureau? We all know about cases right now before those agencies that are dragging on forever. And these are real questions we have to answer when we're putting provisions in law. So while we are, to me, doing the right thing by doing the legislation and bringing it to Parliament for protection of the citizens, we have to make sure that they can work and that the agencies that are charged with the responsibility of applying them do so in a diligent manner and consistent manner. And there must be consequences for lack of compliance. And I'm not seeing that built in. So I will tell you that raises a lot of concerns for me. Madam President, I also want to raise the issue of the updating of the website and the website itself, because Senator C. Prasad asked of the Attorney General while he was piloting the bill about the inactivity of the website. And that's already very telling. So we put provisions for a public website, and as is built into the bill, to be updated in 7 days, as the law or the provisions here outlines in this bill. and the website goes down because the bill specifically states maintenance and update, and it goes down. What is the mechanism and or consequence for it not being maintained, it going down and it not coming up? And we have to also raise the very real specter in today's context of cybercrime and hackers and persons who may, for whatever reason, nefarious reasons at that, decide to try to breach this website and manipulate it in some way because it's a public website. We've seen hacks of major conglomerates in Trinidad and Tobago who have resources as private sector conglomerates to have critical IT infrastructure and personnel to deal with that, but they still fell prey to cyber attacks and hacks and getting access to people's information. We've seen in other jurisdictions, or right here, we've heard about banks being subject to breaches because of hackers. Now you can imagine if someone wants to create mischief, for example, and this website is public, and they hack that website and put the name of a public official on the website out of mischief. And the person's charged with responsibility are not diligent, and that stays up there, people screenshot it and spread it around. Think of the kind of mischief that can do if the systems are not in place and if the agency is not held accountable for strict maintenance and compliance as the law provides for. That is not our job necessarily as legislators, but we have to consider it when we're making law in this environment, given what's happening in the world. And we would know in any research that you do online, any quick Google search will show you the exponential rise in cyber attacks and hacks to major corporations around the world. The TTPS is not exempt. And the TTPS is going to be responsible for the maintenance of the site. And the implications are dire for people who are intent on mischief. Madam President, I didn't intend to be long, so I will start wrapping up now. I also think the issue of public awareness in a particularly small jurisdiction is very important. I think if we are making law as groundbreaking and as novel as this, especially in light of the provisions that are intended in this law, that we have to do more effective public awareness programs and education programs. Because, for example, as the Honorable AG indicated, a family who may have been subject to one of their members being abused can go to the TTPS and ask for information regarding a particular convicted sex offender. But then there are limitations to what they can do with that information. Because if they go beyond the parameters of what the information is supposed to do for them, they will also run afoul of other parts of the law and end up themselves with criminal liability. And so, even though the original law has been passed and updated, and there are several aspects that are active, I myself have not seen an effective, consistent public awareness program telling the public what this is about, because I was part of the SSC, and that was heavily discussed in the Special Select Committee, in terms of the public understanding what this is about, what the difference between the National Sex Offenders Registry, which is not public, and what the website is intended for, and what the information on the website can and cannot be used for. And I think that is also very important when we're considering this kind of groundbreaking novel law that changes the paradigm in Trinidad and Tobago, because we have to learn from other jurisdictions and what has happened consequent to them not considering these possibilities when they enacted their laws. Because as the Honorable AG says, there's several jurisdictions, including some states in the US and some states across Europe, that have, and in some instances, have actually started and discontinued public registries because they did not achieve the intended objectives. So I think, in wrapping up, I agree with and support the proposals in these amendments, because I think they, in some instances, correct lacunas that have existed before, and they balance the issue of the rights, the privacy rights of the convicted once that person has gone through the legal system in its entirety, versus the protection of citizens who are victims of sexual abuse, in particular children, and who also may become victims in terms of knowing sex offenders in their general locality. But I think there must be more specificity in terms of what this locality entails, because the interpretation of that can be wide and dangerous if someone gives a particularly narrow locality in terms of probably a specific address or a street where the possibility of vigilante justice, stigmatization, and stereotyping of a street, an area, or a particular family home or dwelling may be concerned when other members of the family had nothing to do with the crime perpetrated, and they fall victim to the victimization based on association or based on familial relationships. So as I said before, I support the proposals, but I think we also need to consider including clearly outlined penalties for non-compliance, particularly regarding the responsibilities assigned to the Trinidad and Tobago Police Service, in specific reference to the very narrow requirements that are proposed in this legislation in terms of the reporting, updating, and maintenance of the website. And with those few words, Madam President, I thank you.
Senator Lezama Leasing.
Thank you very much, Madam President. It is my pleasure, indeed, to join this debate on the amendment to the Sexual Offences Act, on this lovely occasion. Madam President, I remember in December 2020, reading a newspaper article titled, "Court Orders First Man to Register as Sex Offender." And this is an article by Jada Lutu in the Newsday on Wednesday, the 9th of December, 2020. And I remember feeling a myriad of emotions. I was happy, I was sad, I was frightened, I was excited. I wasn't sure, but one thing I knew was that my government was acting in my best interest. You see, that article, and I just quote the first paragraph, "A 37-year-old man convicted of 6 counts of having sex with a female under the age of 14 is the first person to be ordered by the court to register as a sex offender." And then the article goes on to list the gentleman's name and other parts of the case that he was tried for. And Madam President, I continue to be very grateful. 1, to the government for its determination to protect the citizens of Trinidad and Tobago, and more importantly, Madam President, 2, for me to be a living part of the effort to protect the people of Trinidad and Tobago. Madam President, the opposition speaker before me started off by saying that the issue of sexual offenders is not one to treat lightly, and I agree with her wholeheartedly. And that's the only thing that I will ever agree with her on. But Madam President, what bothered me tremendously is that the United National Congress, using the cloak, or the removal of the cloak of the heat of the chamber, decided to pick up themselves and walk out when our distinguished Attorney General was presenting his opening remarks for this debate. You see, I am convinced, Madam President, that this opposition never acts in the best interest of the people of Trinidad and Tobago. And I want to ask you as legislators, what message are you sending to the population? What message are you sending to your supporters that you are completely uninterested in what is happening? You are not interested in looking after those who have been affected by sexual offenses? You're not interested in the same name that Senator Richard called? The children who are being affected? The women who are being assaulted? The boys who are being offended? I condemn the United National Congress, who are unable to be mature and civilized in this environment. Madam President, I am part of a team.
Senator Leida, it is not appropriate for you to be shouting as you are, okay?
Madam President, Senator Leida just turned the leaf to a new chapter, and I hope that as he begins this new year of his life, he settles down and he acts in the best interest of the people of Trinidad and Tobago. And don't take chain up from the other people on your bench. Madam President, as I was saying, this government is determined to look after the interest of all the people of Trinidad and Tobago. And the Honorable Attorney General, speaking in the other place, made a very powerful statement. Law does not function in a vacuum. And it is very true, Madam President. We can't take this amendment and expect this to be the be-all and end-all and the protection of all the people who have been offended, sexually offended. You know, the government has put a package of legislation forward that seeks to protect and prevent these things. And when I call the names of these pieces of legislation, Madam President, it is shameful that very often a lot of this legislation has had to be watered down because of the blatant refusal of the opposition to support these pieces of legislation and to act in the best interest of the people of Trinidad and Tobago. Legislation, I want the national population to know: the anti-gang law, the pepper spray legislation, some things with the Evidence Amendment Act, and even some parts of the Sexual Offenders Act where they've been very, very silent, Madam President. This opposition does not act in the best interest of the people of Trinidad and Tobago. Madam President, let me take the opportunity now, as a mother of 3 young girls, to speak through you, Madam President, to mothers in this country. I have an 11-year-old prepubescent daughter. Very, very lovely little girl. Very respectful, polite, but certainly very naive and unsure. And I walk with her, and sometimes I see older people who ought not to be doing these things ogling at her. And Madam President, as a mother, you become terrified at things that can happen like this. And from a very personal perspective, I certainly would want to know if there is a sexual offender in my vicinity and within my locality. I don't need all of the specific details. The specific details are posted on the TTP, are kept with the TTPS's register, but on the public register, I need to be able to know. And as mothers and as protectors of children, and as an aunt, and as mothers and as protectors of children, and as an auntie, as a cousin, as a friend of mothers, and even as someone who, I'll skip that for now. As a mother, it is very, very disturbing that you send your child out there, and it happens everywhere in the world. So Trinidad and Tobago, this is not exclusive to Trinidad and Tobago. That there can be people who want to put unwanted touches on your child, or uninvited touches, or the assault, or the worst possible things that can happen to your child, or to you, or to your friends. And as mothers, we are very, very cautious about the environment. And so I stand in strong support of this legislation. Madam President, I want to speak to the improving the information on the registry, where the information related to the registered sex offenders includes the name and former names and aliases. We know in Trinidad, you could change your name, or you have plenty aliases in this country. Your date of birth, the sex and photograph, your locality, and the convictions of what your offenses have been, including the date of each conviction. And I think this is something that is very strong. I think this is something that is very important as we seek to continue to protect the people of Trinidad and Tobago. And as I said, law doesn't operate in a vacuum. So there are other programs, for instance, put on by the government to support and to prevent these kinds of incidences from happening. You have, for instance, the Ministry of Gender Affairs conducting a number of men's empowerment and men's building programs to try to get men to not go in that direction. You have the Ministry of Youth Development and National Service, and they have a myriad of programs, and I want to compliment the Minister of Youth Development and National Service for his tremendous work in championing efforts and initiatives for the young people of Trinidad and Tobago. A number of initiatives there, the agricultural program, the Learn to Drive a Backhoe program, the MyLat and MyPat and all of the other programs there to keep people away from a life of crime. You have the Ministry of Education. In the Ministry of Education, the number of guidance counselors in schools, sustained within the schools to try to keep the children on the correct paths. The Ministry of Community Development, which is responsible for all the village councils. And you know, when you have the village councils, you build community. When you build community, you become the brothers and sisters keepers. And that is what we are lacking in this country. And as we talk about building community and being our brothers and keepers, sisters, Madam President, I am very taken aback, but not surprised that the presenter for the UNC so far continues, since the start of the senator's tenure here, to undermine, in my opinion, the efforts of the TTPS and even to an extent the work of the courts of Trinidad and Tobago. Because every time we come here, she talks about they are unable to do their work. And she's not saying it necessarily in a way that specifically only is to resources, but she's also very often almost making it a sustained attack on the persons within the institutions, and that is undermining of the independent institutions of Trinidad and Tobago, and the PNM will not stand for that.
Next, please, I need your guidance on this.
Yeah. So, Senator, I will ask you to. You've said certain things, but you're saying it about a member of this chamber, so I will ask you, please, to move on.
And I will move on. Thank you, Madam President. I just wish to say that the PNM continues to do what it can to support all of the institutions in Trinidad and Tobago that will seek to bring justice, relief, and support to the citizens, all of the citizens of Trinidad and Tobago. And Madam President, there is not much more that I need to add to this debate, because it is, as much as the debate is very important, it is really very simple legislation, and we will see more things coming forward. I wholeheartedly support and commend this amendment. I support the Attorney General in his work and in his diligence, and I look forward to extending my support and to getting the support from other members. I thank you, Madam President.
Senator John.
Thank you so much, Madam President, for the opportunity to contribute to these amendments today. Madam President, we have had prior amendments to the Sexual Amendment Bill, and what is needed now is really the work with the implementation. I think Senator Lutchmedial was making that point, and that was not necessarily negative criticism. She was just pointing to an issue of fact, because all of these amendments have not yet been consolidated within the revised edition of laws, I think, in Trinidad and Tobago. So therefore, one had to look a little all over with respect to these new amendments to see how they relate. Madam President, it appears as if notwithstanding these many amendments, it remains a work in progress, and we know that will be so, but at least one needs to get moving with the work, because the crimes associated with this bill are an epidemic in the country, and everyone, all the speakers have alluded to that, and they support that. And certainly, one does not want to know that a child is being affected in this way, and we can do something about it. So it's not about any negligence. The opposition, in the last amendment, which came, I think, last year, we voted in this House. It was a unanimous vote in this House, Madam President, and I think it was our duty so to do. Madam President, when former Attorney General Faris Alwari, when he piloted this bill. He said it was intended to create 2 registers at the time, the National Sex Offenders Register, which will be private and for the use of law enforcement only, and then the public sex offenders website, which I think these amendments, they speak to the part of that website that the Commissioner of Police, he will have a responsibility for in terms of the update. And this new section 48, which is further amended by the addition of new subsection 8, after the existing subsection 7, this new subsection mandates the Commissioner of Police to update the information on the website without delay. But first, Madam President, there need to be, well, I mean, there is an existing website. I went to look at it, but it has nothing on it, well, as it relates to sexual offenders. And Senator Lutchmedial made a point that there need to be convictions, well, detection and conviction, and that is what will feed into this website. And I don't see that as being obstructionist or negative. She's making a point, which is a point of fact. So the Commissioner of Police shall, in relation to the sex offender, have control of the website to be known as the Public Sex Offender website and designated for the publication of information referred to in subsection 4A. And Madam President, I said this website is still outstanding and still wanting. And it's not because, I mean, there are many, many, many sex offenders in this country, and too often you see this, these stories reported in the newspaper, and I think it appears as if we have now stopped being so shocked by it. And I'm not saying me, because I remain very shocked that even yesterday a grandmother called me to tell me her very young granddaughter had been raped and is now in one of our institutions. And it's very painful when you hear these things and you're wondering, will this person ever be caught and brought to justice? And it's really not easy. Again, the former Attorney General, in presenting to this very House in 2021, he said for the period 2015 to 2020, the number of cases reported of abuse against children are 27,837. And of that, 6,402 of those cases are for sexual abuse alone. This is a horrific statistic, Madam President. And what is grippingly horrific is that the cases for sexual abuse of children include children between the ages of 0 to 4 months. And many matters of rape, human trafficking of women and children are reported in the media. And I'm certain many of it goes unreported because sometimes people are thinking about the shame of it, the stigma attached to it, and really being safe, going to a safe place to report these matters of people who have been committing these very serious acts. Madam President, just a few weeks ago, in a REMA, in the full view of residents, there was a raid made on some house that is in the full view of the residents of a street called John Straw Street in a REMA, where there was activity of human trafficking and child prostitution. And Madam President, in terms of what is under the Children Act, Chapter 4601, the definition of a child is a person under the age of 14. So imagine under the age of 14, they have these children engaging in these acts. Now, there were arrests in this case, but one wonders whether these people are now just, while the matter is making its way to the court, where are these people now? Does their neighbor know what these people have been engaged in, or they're just left out there to continue what they have been doing? Because one of the persons arrested was 21 years old. This is a very young person engaging in these things. So, Madam President, a functional, well-managed public sex offender registry, which will, I mean, if it's working, will help to name and shame, because this is a very small country, and basically, I think Senator Richard had made the point, it's a small society, and people gossip. And if it is, it will not, the sex offenders registry, I suppose, will have help in terms of people carrying across that word, but at least it needs to be well populated and give people a fighting chance to know who they're living next to, because these registries are supposed to protect families, especially children, within communities from any potential harm. It could make or break a decision of where you decide to live. I mean, it's not to stigmatize that a place has more potential or have more existing sex offenders than the others, but certainly you want to know who you're living next to. It helps police in investigations and trying to understand who a suspect is and what he and she have done. It provides people with the right to know where and who the sex offenders are, because these sex offenders really meshed and they really a part of our everyday life. They find themselves in places where they are children and the vulnerable. So, we keep amending this bill without really the implementation before it, and I think that is the point Senator Lutchmedial was trying to make very forcefully, and it should be made forcefully, because if this is one of the tools, the government has decided this is one of the tools, and we agreed because we have voted in support of it, then really and truly we should get it done. In addition, Senator Richard spoke about public awareness, because we have these mechanisms, but we are not telling the public that this is available, to help you, and so they can understand and they can participate. In the United States, they have a sex offenders registry that the FBI manages for 350 million people, and we have approximately 1.4 million, and we just cannot appear to get it done. Although we have all of these reports coming out ever so often. As a matter of fact, not too long ago, I saw where a report by Camille Hunt of The Express. She was talking about a particular individual who was arrested, found with pornographic material involving minors. And very distressingly, Mr. Clarence Mendoza, president of the Trinidad and Tobago National Council of Parent Teachers Association, he said he has described this as an ongoing problem within the country. He said child pornography is rampant in Trinidad and Tobago, and this leads to other behaviors. Madam President, I see you're pulling your mic, but Madam President.
Senator John, because while all that you're talking about is of interest to everyone in the chamber, I really do need you, though, to deal with the specifics of this bill. And this bill it's very limited in scope. I know that everyone would like to talk about what leads to having to implement these kinds of measures, but this is not the debate for it at this stage, yeah?
Then I am guided. But I think every opportunity we get to just reinforce, because this is such a serious crime. We are just trying, Madam President, with all due respect. Then we had a goodly Senator D.L. Singh making a lot of, he was interviewed in the newspapers, and I wouldn't go into it, but really and truly he hit the nail on the head, when he spoke in great detail about, all of what leads to this kind of behavior. And he suggested that in addition to the sex offenders bill, we have a cybercrime bill and so on, because all of these are various strands of the abuse of our children and the vulnerable in our community, Madam President. Again, there was another article, I think last week, Sunday, with Denise Wren, where there's a growth, it said child sex abuse, addiction in Trinidad and Tobago. And again, it talks about, this thing is very widespread. So therefore, as a result of that, it has the potential that these folks who involve themselves in all of these materials are predators on our children. And basically, it is something that we need to treat with very, very urgently. And of course, as this bill is giving a mandate to the Commissioner of Police to, well, when that website is up and running, that he must update regularly, because if the website is not updated regularly, then it defeats the whole purpose of this monitoring, etc. So, Madam President, in light of the epidemic committed in this country, I think no stone must be left unturned in ensuring that we root it out, or at least be able to give the victims, unfortunately, the victims some measure of assistance or hope that there is something that is being done in terms of prevention and deterrence when it is fully activated, because I think this sexual offenders registry, that is the role that it sees it playing. And as the Right Honorable Sir Dennis Byron had said, President of the Caribbean Court of Justice, as he presided over the presentation of the model guidelines for sexual offense cases in the Caribbean, he said, it is our responsibility to ensure justice is served in the most efficient and effective ways, that the innocent are quickly exonerated and the guilty made to account, and that we make every effort to minimize inflicting further harm to survivors of sexual assault who seek the support and protection of the criminal justice system. And I think this is another piece of the bill that it's trying to do. So, Madam President, too many of our women and children are suffering, and this bill needs to be fully proclaimed and every aspect activated in the best interests of our citizens. Thank you, Madam President.
Senator Thompson-Ahye.
Thank you, Madam President, and welcome back. It's just 1 year ago since this Senate amended the Sexual Offences Act, Chapter 1128, by the Sexual Offences Amendment Bill 2021. And here we are again in June 2022, re-amending the much amended Sexual Offences Act by way of the Sexual Offences Amendment Number 2 Bill 2022, and with the Sexual Offences Amendment Number 3 Bill sitting in the waiting room, anxiously awaiting our latest legislative intervention, and no doubt wondering if the legislative procedure we would be required to perform would be surgical or medical, life-saving or cosmetic. Prior to last year's amendment, the Sexual Offences Act 1986 was amended in 1994, 2000, 2012, 2018, 2019, and 2021. The year 2000 was the revolutionary year for sexual offenses. That year, Parliament legislated that a husband could be guilty of raping his wife, although that rape was given the gentler title of grievous sexual assault. That year, too, reporting of child sexual abuse was made mandatory, and most relevant for our purposes, the court was empowered to impose on convicted sex offenders notification requirements for specific offenses, with the notification periods being dependent on the term of imprisonment imposed on the offender. The 2000 Act also itemized a method of notification, penalties for noncompliance, and for a purported compliance by giving false information. At the outset, our law made it clear that our system of registration of sex offenders was based on the sentences imposed on conviction and was not directly related to the offense committed or the level of risk to potential victims, as some other jurisdictions are. The next operation we performed on the Sexual Offences Act was to enact the Sexual Offences Amendment Act 2018, when we inserted in its Section 37 the National Sex Offender Registry. This applied to a citizen, a person in Trinidad and Tobago, or a person who committed the registrable offense in Trinidad and Tobago. This registry was not accessible to the public and was required to contain particulars of the convicted sex offender as listed in a schedule, which was Schedule 2. The particulars included, inter alia, the name, the former names, the date of birth, the sex, the main address or secondary address, and I wondered why or rather than and, because people have different addresses. The registry was placed under the control and custody of the Commissioner of Police, who was to ensure that the information inserted was correct. It's interesting to note that in Jamaica, the registry is under the control of the Commissioner of Corrections. Section 38 of the 2018 Amendment Act specified certain information in relation to each registered offender be made accessible to the public via a website designated for that purpose. This information was A, name, former names and aliases, date of birth, photograph, main address or secondary address, offenses committed, including dates the offenses were committed. The commissioner was to ensure that this information was to be displayed in a conspicuous place in each police station to which a registered sex offender was required to report. It is to be noted that the required information does not include sex of the offender. In the 2019 Act, the next procedure was conducted with much self-backslapping, for it established a sex offender register in Section 47(1), which became Section 46A(1) in 2021. The establishment of the registry had been outstanding since 2000, so the then Attorney General was justifiably proud and was not too shy to so proclaim his success. The information on the convicted offender, which was required to be included in the register, was listed in a schedule, Schedule 3, and was more extensive than the list of information required under the 2018 Act. But it also required that the sex of the offender be included on the register. This register was not accessible to the public unless the court determined otherwise. It was to be under the control and custody of the Commissioner of Police, who was to maintain it, to ensure the information on the register was in accordance with the Act and any other written law, and that it was accurate and protected from unauthorized access, collection, misuse, alteration, disclosure, or disposal. The 2019 Amendment Act by Section 48 also created a sex offender website, which was to contain certain information in relation to a registered sex offender, namely the name, former name, aliases, date of birth, photograph, main address or secondary addresses, and the dates of each conviction of registrable offenses committed by the registered sex offender. The website was also required to have a notice displaying in a conspicuous place warning of prosecution for the intentional and unlawful reproduction, sharing, or use of information contained in the website. Penalty for the breach of this section was a fine of $25,000 and imprisonment for 3 years. Whereas the particulars of the convicted sex offender that were to be placed in the registry and on the register included the sex of the offender, this requirement was not included among the information pertaining to the convicted sex offender, which was required under Section 48 to be placed on the website. Each police station was to display the information, again in a conspicuous place, in the police station. Clause 4 of this bill now seeks to amend the Act to include the word sex before the word photograph, so we would know the gender of the offender and have it included on the website. One cannot help but wonder how this omission came about. Was it oversight or deliberate omission? I must strike a note of caution here, though, with the growing awareness of gender dysphoria, which has been described as the distress a person feels due to mismatch between his physical or assigned sex and his gender identity, and the availability of gender reassignment surgery, evidence of which came before our very eyes not too long ago, and with the fluidity of definitions of gender that now obtains, and which sometimes put feminists on a collision course with His Holiness our esteemed Pope, I trust that there is available within our legal institutions the requisite competence to cope with any problem we might encounter in striving to be accurate and fair. This issue may very well turn out to be a major human rights case that we will never forget. Section 48(3) of the Sexual Offences Amendment Act 2019 gave the court a discretion to determine whether or not a person convicted of a sexual offense should be registered as a sex offender. Section 49 of the 2019 Amendment Act empowers the court to make the order for registration of a person as a sex offender to decide on the duration of the reporting period, its frequency, on whether or not the information on the sex offender should be published on the website, and the power to order a reporting period less than that specified in the schedule. The court, however, in making its decision, must consider various factors, including a mental assessment report from a psychiatrist. Under Section 50, an appeal operates as a stay with regard to a determination by the court on whether a convicted sex offender should register or report. The Sexual Offences Amendment Bill 2021 now made certain changes, including widening the application of the Act to a sex offender convicted of a registrable offence within or outside Trinidad and Tobago, and provided for the establishment of two registers, the National Sex Offender Register and the Public Sex Offender website. Now, remember the 2018 Act had established a National Sex Offender Registry and provided that information on each registered sex offender be made accessible to the public via the website. And I am grateful that the Attorney General did take some pains to explain the development of the register and the registry and the website. So today, as we go round and round the mulberry bush of the National Sex Offender Register, the National Offender Registry, and Public Sex Offender website, with the attendant danger of becoming quite giddy and disoriented, we are presented with yet another bill, the Sexual Offences Amendment No. 2 Bill 2021. Madam President, Section 43 of the 2018 Act required a registered sex offender to notify a designated officer of the information set out in Schedule 2 and provide documentary evidence of the information at the time of making the notification. This provision is repeated in Section 47(2) of the 2021 Amendment Act, which refers to the relevant schedule as Schedule 3. When you look at those two schedules, we see a list of information to be contained in the National Sex Offender Registry. In both cases, the word sex appears. In the 2018 Act, it is the third item, and in the 2021 Amendment Act, is the fourth item after place of birth. So we have name, former name and aliases as number 1. Then we have number 2, date of birth, number 3, sex, 4, place of birth. So it seems the error was made when the provision in the original bill to have the information on the register placed on the website was not followed. Now, this wastes legislative time and reminds me of a childhood lesson. For want of a nail, the shoe was lost. For want of a shoe, the horse was lost. For want of a horse, the rider was lost. For want of a rider, the battle was lost. Despite the lack of support when needed, we cannot always be losing the battle to put the best laws on the books, especially when we need to protect the most vulnerable among us. Clause 3 of the bill would provide for the interpretation of the words, the act to mean the Sexual Offences Act, Chapter 1128. Madam President, that act, as I've mentioned, has undergone so much surgery, even its mother would not recognize it. Sifting through the consolidated version prepared by the Legislative Drafting Department of the Ministry of the Attorney General and Legal Affairs offers some comfort, but it is not so easy on the eye. It's challenging in some respects and already outdated. As someone who has been a legal professional teaching institution for 27 years and still am an avid researcher, I say without fear of contradiction that the state of our laws, not having been updated since 2016, are a researcher's nightmare. We need to do something about it and do it urgently. Clause 4 also proposes the next amendment sought. That is, with regard to the Commissioner of Police updating, without delay, the information published on the website in relation to a sex offender or registered sex offender where there is a change in the information published. Now, I heard the Attorney General speaking about what happened. I didn't hear it in the other house. I missed that part of the debate. But he did talk about without delay. Now, to me, the phrase without delay does not mean the same to everybody. I can tell you several stories, but I will spare you today. and persons whom I cannot bring into the debate will be grateful. Suffice it to say that I propose a specific time frame for updating the website with the new information. Failing a specific time frame, I would recommend the use of the word promptly. Somehow it gives me greater comfort. Clause 5 of the bill seeks to amend Section 56(2) of the Act by removing the word offense and replacing it with the word sentence. The error was clear. Now notice I did not say pellucidly clear, as tautology makes my non-existent bristles prickle. I support this amendment though. Clause 6 of the bill seeks to amend Section 57 of the Act. Section 3C provides for a designated officer to verify the accuracy within 7 days of receipt, the information received from a registered sex offender, and to provide for a verification of the information rather than its mere receipt. And 4B, this amendment provides that within 3 days of recording any changes in the information provided by a registered sex offender, that information must be forwarded to the Commissioner of Police, who must, without delay, update the information contained on the website. Section 48. Information relating to the registered sex offender includes the name, former names and aliases, date of birth, sex and photograph, locality in which the sex offender lives, and convictions of registrable offenses committed by the sex offender, including the date of each conviction. Now, I have a sneaking suspicion that that will not be the end of amendments to the Sexual Offences Act, and we will be going around the mulberry bush once again. Only Trinidad and Tobago, Jamaica, and Belize have sex offender registry. It's not a priority in CARICOM, but it should be. I would wish to see included among persons subjected to sex offender notification requirements as obtained in the Belize Criminal Code, a person who is found not guilty of a sexual offense by reason of insanity or disability having committed the act of which he is charged. Because frequently you have people who seem non-compos mentis, but when it comes to sexual acts, they know what to do. And they do it sometimes, and it should not be with impunity. So one ought to look at that. The children need to be protected. Remember, as a little teenager going to a cinema, and there was a guy there, he's still walking about Port of Spain, so he's very, very old, and, he used to want to touch us. Now, I found the Jamaica Sexual Offences Act and regulation made the under to be very detailed, and I would commend them to our draftsmen for our future deliberations. We are in a crisis as far as sexual offenses are concerned. One may even say we have an epidemic. You may have seen a newspaper headline in Sunday's Express newspaper about 2 weeks ago, child sex abuse addiction in TNT. It spoke about a lively trade of child abuse material being shared on the dark web, which involved trafficking in children as well. I should also like to refer members of this chamber to the Committee on the Rights of the Child General Comment on Children's Rights in relation to the digital environment that was published last year, and ask if all children's rights are sufficiently protected in law and practice. It would be useful to hear from the Children's Authority and the Child Protection Unit about the number of children who are lured from their homes to meet the boys and men they have met online. And I have received anecdotal evidence, which of course I cannot share. What I should like us to bear in mind is that the origin of publication of sex offender registry began with Megan's Law and the need to protect children from predators. With the explosion of online offenses, which provide deadly threats to childhood innocence and the very life of our children, the future of our society is in danger. Children who should be playing and happily singing, "Here we go round the mulberry bush," are crying out in pain every day and night, pleading for our care and protection. Let us stop failing them and provide the protection they so desperately need from monsters in human form who dwell among us. While a sex offender registry is desirable, it is no silver bullet. Excuse me. It will not eliminate sex offenses from our society. Many sexual offenses are not even reported. When reported, many are not properly investigated, especially in cases perpetrated by strangers. For example, those perpetrated in the context of home invasions. Our conviction rate also gives us little comfort. Research conducted by the American Correctional Association entitled Understanding Policy and Programmatic Issues Regarding Sex Offender Registries published in February 2006 in Corrections Today, revealed severe adverse consequences for offenders that may facilitate recidivism. It also spoke to flaws in the process of registration that impacted both the community and the offender. It informed that, and I quote, the heightened awareness of sex offenders can generally be attributed to the Jacob Wetterling Crimes Against Children and Sexually Violent Offender Registration Act of 1994 that formalized the practice of registering sex offenders in statewide databases. Jacob is a boy who was abducted but was never found. It also said that sex offender registries were subsequently made publicly accessible almost always via the internet through Megan's Law, passed in 1996 in response to a brutal murder of Megan Cantor, a young New Jersey girl, by a registered sex offender living anonymously in the community. The Adam Walsh Act 2006 was named after a child who was also raped and murdered by adult men. It would be a pipe dream to have the Achille Chambers Act. A study by the Medical University of South Carolina on evaluating the effectiveness of sex offender registration and notification policies for the reducing sexual violence against women found inter alia, one, a significant deterrent effect was noted after the 1995, the year that South Carolina first implemented the sex offender registration and notification, called SON for short. But two, that there was no significant decline in the 6-year period after 1999, which was the year South Carolina implemented its online sex offender registry, indicating that online notification did not influence general deterrence of adult sex crimes, and that registered sex offenders were not less likely to recidivate than non-registered sex offenders. 3, that sex offender registration and notification appear to have a positive impact on general deterrence associated with averting approximately 3 new first-time sex crimes per month. The researchers recommended, inter alia, that 1, registration and notification requirements should be based on empirically validated actuarial risk assessment. 2, that we limit online notification to high-risk offenders. And 3, limit the duration of SON requirements. 4, we redistribute resources to collaborative and evidence-based risk management and treatment. We cannot assess the impact of sex offender registration and notification in Trinidad and Tobago. As far as one can tell, and this is the information I got last night, that there's 1 sex offender on the registry. But I heard the Attorney General saying something quite different. And information on the registry cannot be accessed without your providing a name of the offender, because we did try to access. The motive for the offender registry was to protect children from sexual predators. In addition to laws, we need a program of education and training of parents, caregivers, teachers, and children, and the community so that children can be kept safe. Boys and girls need desperately to have a program of sex education and should also be trained in gender issues so they can reject stereotypical roles and avoid the behaviors which characterize the power and control wheel, and learn to operate on the equality principles. Those are the things when we ratified the Convention for the Elimination of Discrimination Against Women, we promised to do those things. They need to understand their sexuality and how to deal with this God-given gift.
Senator Thompson, I have to, you're coming to the end? All right, because, you know, I've been repeatedly saying about what this, to focus on what this bill is about.
I'm in my last paragraph. And I just wish to say that restorative justice is increasingly being used for sexual offenses and preventing recidivism. And that while I agree, a sex offender registry and website are important tools in our toolbox, in our armory, to keep potential victims safe, it is by no means a foolproof solution. No silver bullet it is. Thank you, Madam President.
Senator Hislop.
Thank you, Madam President, for the opportunity to contribute on this Sexual Offences Amendment Bill number 2. I must say that my short time in this House, every time Senator Thompson-Ahye contributes, I sit there smiling, because it is indeed a full contribution that she gives. But Madam President, permit me to begin with a quote from the good book, the Bible. Jeremiah 17:9 says, "The heart is deceitful, and above all things desperately wicked. Who can know it?" There is no doubt that these times that we live in seem to be evil times. We also need to accept the fact that any and all governments are unable to categorically eliminate all crimes. But I must say that this administration has indeed shown its willingness to treat with all issues that affect the citizenry. And today, Madam President, this Senate is being asked to treat with what I would consider small but significant amendments to 3 sections of the Parent Act. Sexual offences registries, as was mentioned by Senator Thompson-Ahye, may not always prevent reoffending, because the studies have shown that even after you've created a sexual offences registry, there is still reoffending. So no law, Madam President, is foolproof. But laws do act as a deterrent in one form or the other. If this legislation, if these amendments saves one life or prevents one offense, then one is more than enough. The technology has, as we have seen in the 2002 science fiction movie Minority Report, starring Tom Cruise, is not yet available, where a group of persons called precogs have the ability to predict that an individual will commit a crime before he or she actually does it. We still have to have laws. We still have to create laws to act as a deterrent. We still have to depend on the police service to investigate when a crime has been committed, and the judiciary to convict the said criminal based on the laws we create. Because, Madam President, no matter how many laws we create, there will still be someone who will think that he or she would not get caught. Or in the heat of the moment, logical thinking goes out the door and a crime is perpetrated. An examination of the amendments, Madam President, show a very clear direction that the Sexual Offenders Registry will seek to take in its operation. There's a drive for this registry to be clear, precise, and timely in its gathering and dissemination of information. All of these factors are essential for the proper operation of the registry, of a registry of this nature. We accept that such a registry bears information that is sensitive, critical, and aimed at preventing sexual violence and or reducing or eliminating the rates of sexual reoffending. And Madam President, the timely updating of the information to the website can act as protection for not only the community, but even the offender. Because we know that persons are less likely to reoffend if eyes are upon them. But the truth is, while this may be so, it must be done against the backdrop of clarity, preciseness, and timeliness. Failure to do this can potentially undermine the entire system, and this is what we are seeking to prevent today. This government has given its firm commitment to strike against all forms of crime and criminality. Once again, we are seeking to tighten any loopholes, and we see that in Section 57, which speaks to giving the police commissioner that time frame and asking that the information be updated to the registry in short order, or to the website in short order. The former Attorney General, in piloting the bill in 2021, said, "For too long the society has seen the rampant commissioning of sex crimes, including the most savage and brutal attacks against women, children, and even the elderly. And we heard the names this evening. We heard Akil Chambers. And it is time, Madam President, that we all band together, not only as legislators, but as a country, to, if not eradicate completely sex crimes, but to make it even more difficult for perpetrators to even consider committing the crimes. You see, Madam President, with the noted and frightening increases in sex crimes, these proposed amendments seek to give more detail about the offender and to provide a more robust and time-sensitive approach to the system of monitoring and updating. And this can never be viewed as a drawback, but should be welcomed by all, including my colleagues on the opposition bench, because I know all the government bench is in full support of this work. What we are doing today is to protect all of Trinidad and Tobago. My support, Madam President, for these amendments is unwavering. And we need all on board. We need all to see that it is now to give Trinidad and Tobago that added help that it needs. What we are doing here today is significant and important as we seek to protect all citizens, as we seek to remove the veil of secrecy that has blanketed our communities and our country where sex crimes are concerned. And so, Madam President, I give my full support to these amendments. Madam President, I thank you.
Senator Mark.
Thank you. Thank you, Madam President. Madam President, it gives me great pleasure to join this debate and to make a limited contribution to this bill that is before this Honorable Senate. A bill to amend the Sexual Offences Act, which is known as the Sexual Offences Amendment Number 2 Bill 2021. Now, Madam President, whenever the government brings a bill on seeking to change or to bring changes to legislation that will provide greater protection to our women and to our girls and children, outside of seeking to strengthen and improve the legislation, the United National Congress has always, as far as I recall, supported legislation to protect, to safeguard, and to defend our women, our girls, and our children against the relentless assaults and attacks by predators and criminals in our society. But Madam President, you would also appreciate that as the alternative government, we have the responsibility to safeguard the integrity of the process in whatever we are doing. So when we walk out, whenever the Attorney General rises to speak, we feel strongly about the position taken by our Attorney General on a matter that is extremely serious in this nation. So
Senator Mark, yes. I don't want you to go further than what you've just said. Okay? Let's try and...
Condemned. We were condemned. And I am putting on the record, Madam President, that we condemn the statement made by Senator Lezama condemning our party, when, Madam President, it is clear, crystal clear, that we have supported and we will continue to support good law to improve legislation to protect our women. So we take strong umbrage by anyone making statements that is designed to convey the wrong impression as it relates to our role and our responsibility in this Parliament. So I just wanted, Madam President, to clear the air on this matter. Madam President, we have to recognize that, as Senator Hazel Thompson-Ahye said a short while ago when she addressed us, we were here debating an amendment to the Sexual Offences Act. In 2019, we have an amendment to that same act in 2021. Madam President, if you go to 2021 piece of legislation, which is what has been amended in several respects before us and before this Honorable Senate today, you would see where we recently brought changes to this act. It is called Act number 13 of 2021, where we supported the establishment of 2 sex offenders register, one for the police under the direct police control. Of course, the 2 registers are under the police commissioner's control. But as you know, one is called the National Sex Offender Register, and the other one is called the Public Sex Offender Website. And we supported both. In fact, we wanted the register for the public, right, to have much more information than it currently contains. But of course, we had different viewpoints and we had to compromise. But Madam President, why are we here today coming to make certain amendments to legislation that we just passed? Legislation that we passed, Madam President, that is yet to be proclaimed by this government. So we are amending legislation that has only been assented to, has not been proclaimed by this government. Is this government serious, Madam President, when it comes to sex abuse or sexual abuse of children, of women, of girls? Why has it taken so long? So we are engaged really in what I call bad law, piecemeal legislation, half-baked legislation. And Madam President, we in the UNC are concerned and always will be about good governance and the security and safety of each and every citizen, particularly our women and children. Madam President, when you look at the legislation that we have before us, we are asking the police commissioner, and when you go to the amendment to the legislation, designated officers who are police officers, to do more. We are giving them more responsibilities to execute and to effect what we are seeking to amend today. But we have to ask the question, Madam President. This police service is under-resourced. They are overburdened. They are overworked. And they are not properly appreciated. So we are giving them more functions to perform, more duties to carry out, Madam President, and we ask the question, are they up to the task? Is the government providing and resourcing them as they ought to be resourced so that they can do their job? Because, Madam President, as you would see in the legislation before us, timelines, time frames are given in which, for instance, information must be corrected once it comes to the attention to the police commissioner. Once it is properly verified, you must amend, you must change the information that is on the public sex offender register. But, Madam President, you know what is also critical when we are addressing this issue of the public sex offender register, where the police commissioner is being asked, Madam President, to deal with updated information on sex offenders or registered sex offenders. We have to recognize, Madam President, and I think someone made a point earlier. Is it my colleague out of Tobago, Senator Hislop? He was making the point, and it's a very important observation. Legislation alone will not solve the problem. We have to look at it, Madam President, in two perspectives. There is need for legislation that we are addressing, but there's also need for us, Madam President, to look at what is called non-legislative initiatives. We must take non-legislative initiatives as well. But the government, for whatever reason, I believe this government is tired and they need to go home. The government is tired because when they bring legislation to the parliament and we have to come back within less than 24 months or less than a year to amend the very legislation that they've just brought, the question here that has to be asked, what is happening in the office of the Attorney General? Isn't the Attorney General and his drafting department, didn't they recognize, Madam President, that there's need for an amendment? So we have photograph, and we are being told, listen, we have to amend that because we need to identify the sex or the gender of the person. So when we were crafting, Mr. Vice President, this legislation, we didn't know these things. Is that an excuse, Mr. Vice President, to delay the legislation? So we are back a couple months later to make these what is called minute changes and amendment to something, Mr. Vice President, that ought to have been looked at before. So we are very concerned. We are very concerned. And Mr. Vice President, I want to tell this Honorable Senate through you that we could instruct the police to update the register once new information is brought to the police attention on a sex offender. We can do that and many more things. I want the Attorney General, when he winds up, I won't be here to hear him. But I want him to tell the country. I want him to tell the country, since this public sex register, Mr. Vice President, was established by law in 2021, how many citizens, Mr. Vice President, who have been convicted according to the law? You cannot put a person's name on that register for you and I to look at so that we can protect our daughters and our sons and our families from predators who have been convicted in this nation. The question here, Mr. Vice President, that I would like the Attorney General to address, how many, Mr. Vice President, sex offenders who have been convicted are on the public sex offender register? How many? Mr. Vice President, you know, in many other jurisdictions, you know what they are looking at, Mr. Vice President? The information that we have on the National Sex Offender Register, which is much more elaborate and voluminous. It is not available, it is not made available in the public sex offender register. And the question that we may have to ask, Mr. Vice President, is whether the time is not coming or has not arrived for us to place much more information on these sex offenders in that particular register so that the public can have the kind of notification and information to protect their children, to protect their daughters, to protect their girl children, to protect our women. Maybe that is a debate that we may have to engage in the not too distant future. Mr. Vice President, I want to also ask the Attorney General when he is winding up, because I know he has to wind up sometime. He might wind up a debate today, but I know he has to wind up at some point in time. When I say wind up, I'm not talking about...
Point of order, 46-1.
Senator Mark, I hope you were saying wind up.
Up.
Wind.
Yeah, I'm talking about,
Wind.
Yeah. Well, you understand what I'm saying, right?
Okay.
Because I think you are learned, right?
Let's stick to the arm.
Yeah. Thanks, Mr. Vice President. I don't know why this Minister of Trade is jittery. Mr. Vice President, may I go on? Mr. Vice President, the role, I want to tell this Honorable Senate through you, Mr. Vice President, this public sex offender register, where we are making some amendments, and the Commissioner of Police has a role. I want to tell this Honorable Senate that to populate that sex offender register, public sex offender register, Mr. Vice President, you must first catch and prosecute and convict the offender before that name could appear in the registry or the register. Mr. Vice President, it takes 10 to 15 years in this country just to get a proper trial and a conviction. So if we do not catch the criminals who are committing these heinous crimes, how are we going to safeguard and protect our women? How are we going to do it? It takes too long. The administration of justice, the system grinds too slowly in our country. And we need to do something about that. I would like to ask the Minister, the Attorney General, when he speaks, what has happened to the DNA kits that can be used, right? That can be used in order to speed up conviction of sex offenders in Trinidad and Tobago. That is a very important tool in speeding up, Mr. Vice President, the administration of justice and to convict predators and criminals who are offending our women, our girls, and our children, Mr. Vice President. I understand, Mr. Vice President, that some 3 years ago, they arrived at the port. But I don't know where these DNA kits are today. And these kits, Mr. Vice President, can be used to deal with the very matters that we are dealing here today, where you can have a speeding up of the population contained in the public sex offenders register, if we get the correct tools to carry out that exercise, Mr. Vice President. I don't have much faith or confidence in this government. So, Mr. Vice President, I would like to say to this Honorable Senate that these amendments that we are asked to address today, we hope that when they receive final passage, that the legislation would be proclaimed and action taken to defend and promote the interests, safety, security, and well-being of the citizenry of our country, particularly our women, our children, our daughters, our girls, our boys. So we are hoping that this is not another wastage, another wasteful exercise, I should say. We hope that this government reminds me, I'm reminded whenever I debate matters, Mr. Vice President, in this Senate, this government reminds me of NATO, the term NATO. No action, talk only. The key to success, Mr. Vice President, is the implementation of the legislation, the enforcement of the legislation in the final analysis. All we are doing here, all these amendments that we are making, if they are not enforced, but first implemented and then later on enforced, Mr. Vice President, our girls and our mothers and our sisters and our daughters will not gain and secure the protection that they need in Trinidad and Tobago. I am a defender of the rights of ordinary people.
Senator Mark, you're really going off on a tangent now. You need to focus on... Yes. Proceed, please.
Mr. Vice President, as usual, I am guided by your wisdom, as I'm guided by my distinguished President, wisdom. But I just thought it was necessary, Mr. Vice President, to make a limited intervention to at least record our position on this piece of legislation. And we condemn the PNM for seeking to condemn us when they know that we are supporters of proper and good legislation that will promote the interest, security, and safety of our women, our girls, our daughters, our sisters, our children. Mr. Vice President, I want to thank you for giving me the opportunity to say a few words today. Thank you very much.
Senator Dillon-Remy.
Mr. Vice President, I thank you for allowing me to participate in this debate on the Sexual Amendment number 2 Bill number 20 of 2021. And I was here in 2019, where they had the major amendment of the Act. I was here again in 2021 when we had the amendment to that amendment. And like Senator Thompson-Ahye, I wonder what has happened as to why we have not got further than we are today. So my presentation is going to be very brief. And Mr. Vice President, I really want to find out what has caused the delay, because when we gathered here in 2019 and when we gathered here again in 2021, it was with the understanding that this thing was so important and the contributions were very robust, and we understood that this was something that was needed and needed now. When I examine the reasons for the amendments now, the causes for the amendments, okay, so Clause 4 of the bill says that the subsection is amended by adding the phrase sex and before the word photography. Now, I would blame all of us because we all went through that bill. And both houses, nobody picked up that on that registry, something that was there before was now removed, and it was not brought up. And now we have to come back for this amendment to put this, because how could you not want to know what the sex of the offender is? It is not assumed that it's only males who commit offenses. Females can commit offenses too, so you need to know the sex. So and as Senator Thompson-Ahye pointed out, it was there before. It was left out, and we are saying now, I'm not going to blame anybody but all of us. And it is so important that we just make sure that what is being passed now is something that is going to be implemented. And yes, we will have to have changes at some other point in time, but it should not be changes on things that are this simple, is my take on this particular amendment. The other amendment on Section 48, which is further amended by addition of the new subsection 8. And it says this new subsection mandates the Commissioner of Police to update the information on the website without delay. Well, there is a lot of discussion on what does without delay mean. And again, I would think that this is something that you want updated as soon as possible. And I do understand Senator Richards' point as to what happens if the commissioner does not update it within a reasonable time and without delay. What happens then? And I would like the Attorney General to, is there anything that could be put in this legislation to, I know there are penalties for the person who is making the report that they are sex offenders if they do not do it. In the bill of 2019, there are penalties there for that person. But the question is, and I would agree, what would happen if the Commissioner of Police or if the person who is doing the investigation does not do it in a timely manner? The other Clause 6 of the bill, which seeks to amend Section 57 of the Act, the proposed amendment provides that the designated officer must verify the accuracy of the information. And again, we talked a lot about that as to whether 7 days is enough and what will happen if they do not get the information appropriately after the 7 days. I must question, though, Mr. Vice President, we have put here the 7 days, but have we really looked at what are has there been an assessment on the information that is required for the police officer to verify? What type of information the police officer is verifying, and indeed, what is the likelihood that the person will get the information within that time frame? Is 7 days enough, or is there need for more? I don't know, but the question is, this is something that should have been considered before, I think, and now we are putting a time frame of 7 days, and my question is, will that be enough? And what happens if the person does not get the information to verify the accuracy of the information within that 7 days? Mr. Vice President, the Act also calls for that after the information has been verified, instead of simply recording the information in 2 days after receiving, that the information should be recorded after verification, 2 days after verification. I am to ask the question of, are we in 2022, are we doing all these things manually? It was mentioned already, but we have talked about digitalization and all that. But again, in an area that is so important, where you are putting a registry out with information on persons who are likely to be predators, and you want that information for people to know outside there, I would imagine that is something that you need to be doing in a timely manner. So the 3 days and 7 days and all that, I am asking the Attorney General, is this something that could be considered that they should put, as they're putting it in place, make sure that whoever is doing the investigation, whoever is doing the reporting, have the appropriate software, the appropriate internet access, etc., so that things are updated in a timely manner, rather than what we are seeing here. For instance, the amendment provides that within 3 days of recording any changes of the information provided by the registrar, the information must be forwarded to the Commissioner of Police. Again, is the forwarding a file that goes to the Commissioner that he then has to look at, read, and then update? We are in 2022, we are putting a registry out, and I'm asking, because I really do think that we should be seeking to do better. If this is going to be a manual paper trail, we have to do better. I don't know, but I'm saying that if it is not yet considered, and I hope it is not something that will delay its implementation, that should be considered. that it should be something that is being done digitally. Mr. Vice President, as I said, we are not debating here whether there will be a sex offenders registry. That debate went on before, and it was a very fulsome debate. We are talking now about amendments that are supposed to be simple. And my question is, when would this be assented to? Because that is what I think we all would like to see. And with that, those few comments, I thank you.
Minister in the Office of the Attorney General and Legal Affairs.
Mr. Vice President, I thank you most sincerely for the opportunity to contribute to this debate. Of course, we'd recognize that the scope of this debate is very limited based on the amendments that has been brought. Many of the legal issues, of course, were traversed by the Honorable Attorney General in piloting the bill. But during the course of my contribution, Mr. Vice President, there are two things that I will do. I will add a little further on the law as it relates to certain issues dealt with, legal issues dealt with and challenged by the Attorney General in his piloting. And as I always do when I come to this Honorable Senate debate, I would try to address as best as I can some of the concerns that were raised by Honorable Senators. I know I come after the Honorable Senator, Dr. Dillon-Remy. Many of her concerns were addressed to the Attorney General, and I am confident that our most and well-esteemed Attorney General in his winding up will deal with those issues. That being said, Mr. Vice President, I will immediately turn to Senator Mark. Now, Senator Mark asked quite clearly and plainly what is happening in the Office of the Attorney General and the Ministry of Legal Affairs. And what I would say in reply to Honorable Senator Mark is that what I could tell you is what not happening in the Office of the Attorney General and the Ministry of Legal Affairs. And what not happening is another Section 34. What not happening in the Office of the Attorney General and the Ministry of Legal Affairs is an AG who has criminal charges to answer to. So that is what is not happening in the Office of the Attorney General and Ministry of Legal Affairs. And to that end, I want to say to the members, to our staff of the Office of the Attorney General and Ministry of Legal Affairs, again, as I always do when I have an opportunity, I want to put on the record how grateful we are for the efforts of every single department throughout the length and breadth of the office. So to attack the Office of the Attorney General is to attack our employees, and I take that personal. So just stop it. Mr. Vice President, with that being said, I also want to address some other issues, of course, raised by Senator Mark. Senator Mark, he's attacking this government, Mr. Vice President, for having such a short space of time to re-amend, but at least, Mr. Vice President, we recognize that there is a need for an amendment, and we take responsibility, Mr. Vice President, for doing that. Unlike previous UNC administration, who passed legislation, Mr. Vice President, the public must be reminded of this, who passed legislation without having sufficient resourcing for implementing such legislation. And what immediately comes to mind, this includes, Mr. Vice President, the Community Residence Act and the Children's Authority Authority Act. So when Senator Mark comes to this Senate and he abuses the government and he speaks about us not putting processes in place to give and breathe life into these, to breathe life, clearly Senator Mark is forgetting what they did to this country legislatively when they had an opportunity to make it right. Mr. Vice President, Senator Mark would have indicated there is also a need for non-legislative initiatives as well. And I must say that I do agree with Senator Mark, because we must recognize as a nation that crime is not a government problem alone. It is not something that cannot be addressed by a government. It requires a joint effort by all institutions in our society. But I want to also put on the record and remind the Honorable Senator, the TTPS has established 2 units to handle reports of gender-based violence and sexual violence. We have, for example, Mr. Vice President, the Gender-Based Violence Unit, which was established in January 2020, and the Sexual Offense Unit established in June 2020. Other non-legislative mechanisms and methods that took place to deal with such offenses under this government. So, Mr. Vice President, that is in essence as it relates to what Senator Mark is the only thing that I felt was worth responding to. Now, if I may quickly go, Mr. Vice President, with your leave, to a concern raised by Senator John. Senator John said, she rightfully said that people gossip because we live in a small society. And I agree with the Honorable Senator, and to be very honest, that is one of the fundamental reasons why I stand in full support of the public website. I think the more remote you go, and once you come from a village setting, you understand that this public register has always been in existence because people gossip. So, for example, growing up where I come from, a very, very small village area, my Aji was actually my reporter, because she would be the one who would be able to report to us, okay, someone has come into the village, of course, due to, talking to her friends and all of that. And she always knew, she was always able to at least inform me as her granddaughter, don't go there, don't be seen with this one because you hear this, you hear that. And I just want to simply say that it is for that very reason I do honestly agree with the Senator when she spoke about gossiping that takes place in communities. I, of course, understanding, coming from a village that from since in time immemorial, they have been in existence, or has been in existence, what I refer to as this informal sex register. Now, in answer, Mr. Vice President, a concern raised by Senator Thompson-Ahye, the Honorable Senator, she said, respectfully through you, Mr. Vice President, she said, 1 year ago, since we amended the bill, and here we are again. Here we are to re-amend an amended bill. And I know Senator Mark, in his delivery, he also spoke about us being here again to re-amend. Now, respectfully, Mr. Vice President, isn't that the action, and I want to ask the people of Trinidad and Tobago, isn't that the action of a responsible government? What are we supposed to do as legislators? Acknowledge that there may be a deficiency in the law, and just to look good, don't come back to this parliament and ask the parliament to join with us in making an amendment? I shudder to think that any government will operate their business in that kind of manner. Certainly the PNM government will and have never done that. So yes, we take responsibility for coming here again and coming time and time again to amend laws, but the reality is, and while I still consider myself very much a child of the law, a student of the law, we have to acknowledge that the law is not static. The law is extremely dynamic, and as time goes by, there will be the constant need to return to the parliament and make amendments. So just to clear that up, I want to make it clear that coming to the Senate to do an additional amendment is not, in my respectful view, Mr. Vice President, a bad thing. Now, Mr. Vice President, I now want to turn to some of the concerns raised by Senator Lutchmedial. And, I noticed that the entire opposition bench is now vacant. And for that reason, I have to support my colleague, Senator Lezama, when she was reprimanded by Senator Mark for, pointing out and making them out that when an opportunity comes for they to sit here and discuss the people business, and mind you, to represent how much 200,000 or 300, how much ever thousand people that voted and believe in them, they are never here. The Attorney General is not speaking. I don't know if they have an issue with me too, so they walk out because I'm from that ministry. But Mr. Vice President, where is the opposition? Anyway, I will leave that right there, and I will turn to some of the concerns, of course, that were raised by, Senator Lutchmedial. I want to put on the record, Mr. Vice President, that for last year's debate, and it took me some time to find the Hansard, but for last year's debate on the Sexual Offences Amendment Bill 2021, at page 29, Mr. Vice President, of that Hansard dated June 15, 2021, Senator Lutchmedial came to the Senate and stated, and I quote directly from the Hansard, "I wish to say it up front that I will support any measure, any legislative or other measure that would curb the tide of violence against women in this country and children, and particularly sexual violence." So, Mr. Vice President, my question is, the bill before us today, which seeks to rectify from legislative issues pertaining, Mr. Vice President, to the sex offender registry, this same Senator Lutchmedial have a million questions to raise about how we're going to verify information and who going to verify. Now, mind you, she's entitled to raise those concerns, but at least acknowledge that an attempt is being made by the government, by us as legislators, to put systems in place to try to make this thing right. So, Mr. Vice President, also in the Senator's contribution, of course, this is, I'm not sure if she's a shadow minister, the Senator is a shadow minister for the Ministry of National Security. I'm not sure what she's shadowing. I thought, well, I'm not sure if it's the AG too. But anyway, she made the point about the TTPS. And in speaking about the TTPS, the Senator said, without the resources to detect and convict, of course, this amendment would, and this is inter alia, would prove futile. Senator Mark also in his contribution raised the issue of resources. For the benefit of the viewing and listening public, of course our country and the world has been facing an economic crisis, and we understand that. But for the record, if I may respectfully remind all present here, and it took me some time again because I had to go back to those financial books when the budget that we use at the budget, and what I saw there is that under the PSIP, the government provided a total allocation, Mr. Vice President, of 76 million, 76 million point 9 was utilized for the implementation of the TTPS program of works for the fiscal 2021 to address crime prevention and public safety. And in that book, Mr. Vice President, the yellow books, I refer to page 127 of the Public Sector Investment Program 2022 book. So we constantly hear the opposition come and they make it seem as if this government is not serious about crime. We're not investing in crime. Of course, we could only operate. We can't, manna wouldn't fall from above. And, we have to work with the resources that we do have. But certainly, if we go back to our budgetary allocations, it is clear, Mr. Vice President, that what we do have, we recognize as a government that crime fighting is critical, as is evidenced, Mr. Vice President, in page 127 of the Public Sector Investment Program book. Now, Mr. Vice President, what I also found in looking at the soft copy of that book, a total of 9.79 I'm not good with numbers, 75 million, was utilized to execute these strategies through greater use of technology throughout the operations, such as buying body cameras and outfitting vehicles with cameras, GPS tracking devices, laptops, training, and the list goes on. Then what I also saw is that the TTPS expended the sum of 19.7 million for the implementation of infrastructural projects in the fiscal 2021, such as the Roxborough Police Station, the San Rafael Police Station, and we also had a significant amount of injection into the upgrade of works, for example, at the Mova, Marabella, Princestown, St. Madeleine. Mind you, some of those are UNC areas, so clearly it is when they come here and they talk about geographic, I can't recall what the discrimination. Certainly this government, we don't look at things like that. We look at a whole of country initiative, and from those reports that was presented at the Standing Finance Committee, of course, in the allocations that were presented by, of course, the TTPS at the Standing Finance Committee, the evidence is there relative to the kind of injection we continue to make in crime fighting. So, to answer the question, Mr. Vice President, is the TTPS resource? I can clearly say, of course, it is not perfect, and there is still a lot to be desired. But again, as a government, we have been working assiduously with the resources that we do have. And as year to year, fiscal to fiscal, we continue to recognize that crime is critical, and we invest in crime. So it's not that we sit down there and we give the TTPS 2 pence and say, well, make do with that. That is furthest from the truth, Mr. Vice President. So that is on the point, Mr. Vice President. Just, of course, to remind the public, many people who may not have sat into those standing finance reports, where we would have addressed the nitty-gritty of expenditure and budgetary injection into various ministries. Just to remind the public that at least on the records, and of course records submitted by the TTPS, this is the kind of injection and resources that this government has placed in the Trinidad and Tobago Police Service, recognizing that it is critical for us to address crime. Now, Mr. Vice President, if I may deal with another issue, Senator Lutchmedial raised the issue about verification. And this at least is my notes. I stand to be corrected, but this is what, in my recollection, the Honorable Senator asked. The Honorable Senator indicated verification has several forms. What happens if the information cannot be verified? What is the level of verification? Is the offender to be charged? Do you get charged providing wrong information? Now, to answer this, Mr. Vice President, Senator Lutchmedial is again contradicting herself. Her issue is with respect to timelines, Mr. Vice President. We have included, Mr. Vice President, the requisite timelines in Clause 6, proposed Section 57, which gives a 7-day timeline for a police officer within receipt of information to verify such information of the offender. But, Mr. Vice President, Senator Lutchmedial is bringing up the trivial issue of what is happening if the information cannot be verified. And let me tell you why I believe this is a trivial issue. Mr. Vice President, the same way, in pursuant to this the amendment in the legislation, what we are doing is imposing a legislative duty on the officer assigned for verification. So we have a legislative duty imposed upon this particular officer. Now, this police officer, Mr. Vice President, has a duty of care to uphold in the law, Mr. Vice President, the lawful execution of their duties, because it's now legislated that this is a responsibility of theirs. Similarly, a civilian has a duty, Mr. Vice President, to provide correct information to the law enforcement officer. So, Mr. Vice President, thus the onus of verification, we must recognize it's a twofold process. You know, Senator Lutchmedial, I often come here and speak about her extensive, practice in the criminal, in the criminal courts or the magistrate courts and all these courts. But I know if you're any lawyer who really practices in the magistrate and criminal courts will understand how verification works. And verification is not a process that we could only legislate. It is something that the police have to work in conjunction with the accused in order to, or the person bringing the information, sorry, not the accused, where the police would have to now work in conjunction with the person bringing the information in order to ensure that we are able to collate correct information. So verification is not just a legislative issue. It is something that depends on this twofold approach. Now, further to that, Mr. Vice President, if we look at Section 6(2) of the Criminal Law Act, Chapter 1004, it states, inter alia, where a person causes any wasteful employment of the police by knowingly making to any person a false report tending to show that an offense has been committed or to give rise to the apprehension for the safety of any persons or property, or tending to show that he has information material to any police inquiry, he is liable on summary conviction to a fine of $1,000 and imprisonment for 6 months. And the reason why I haven't practiced in the criminal court make reference to this Criminal Law Act, we have to look at the interoperability of law that will kick in for someone who gives false information to the police. So therefore, there's no need in this law, in the current bill that appears before us, to treat with persons who, what going to happen to this man if he give the police wrong information. There's no need for us to do that, because we have other pieces of legislation existing on our books that will deal with persons who put God out of their thought and decide to provide wrongful information or untruthful information to the police. So, Mr. Vice President, that in summary, I believe, is are some of the concerns that I chose to respond to that were raised by Senator Lutchmedial, and I'm sure my well-esteemed and learned senior, he would address other concerns. If I may now respectfully turn to Senator Richards. Now, Senator Richards raised a very, to my mind, a very important question. The Honorable Senator asked the question, he was looking at the antecedents, I want to believe, that is captured, the data that is captured for these defendants. And I recall he said, he spoke about, the Honorable Senator, Mr. Vice President, spoke about the stigmatization of a particular area based on information that is provided on that public record. And I will be very honest with you, that was one of my major concerns as well when we firstly looked at the public, when I was looking at the antecedents and the data that now has to be captured on this public website. But then it dawned upon me that capturing data is not only necessarily a bad thing. And data, we always speak about data and the provision of data and the information and having that data readily available. And to my mind, respectfully, just like Senator Richards, I had that concern. My concern was, of course, relative to sex as well, where, boys, of course, off the bat are deemed, or men are deemed as fundamentally the perpetrators of sexual acts. Senate, and of course, locality as raised by the Honorable Senator. And of course, again, just to reiterate, I too was concerned about the stigmatization. But then I asked myself, imagine what can be done if this data which is captured is used by community groups or is used by civil societies to go into, because we acknowledge that crime is a whole of country problem, and it is something that could only be addressed by every single one of us and every single institution that exists in our society. And then I said to myself, I said, well, you know what? Granted, yes, the negative to having this information may very well be some sort of stigmatization. But imagine the positive side of capturing this data, that whereby we can have other groups in society, even government, relying upon this data which is captured for us to be able to determine what communities really require our intervention. What this data can also be used to assist us in being able to determine where our focus areas should be, our focus groups. So for example, some of the antecedents that will be captured, or some of the data that will be captured. One of the amendments that we have actually brought today, Mr. Vice President, if we look at Clause 4, proposed Section 48(4)(a)(3), we have now inserted the word sex and before the word photograph, right? So imagine what this information, the benefit that this information capturing this data, Mr. Vice President, can of course, the benefit that it could bring to other groups, to the government in creating policy. So as it relates to the concern that was raised by Senator Richards, again, I do agree with the senator because it was a concern of mine relative to stigmatization. But then I thought to myself, I say, but then this information, once used, captured, it can also be used for a good, and it can be used in shaping policies and putting certain things in place for us to really be able to dig deep and deal with crime, not just from a punitive standpoint or a legal standpoint, but really and truly in creating policies that can have impact on the lives, Mr. Vice President, of our citizens. Now, Mr. Vice President, so that was one of the things raised by Senator Richards that I wanted to address. Senator Richards also, in his deliberations, he addressed the concerns, I believe, at least based on the notes that I have, with no penalty being placed on the police because we use the word without delay. And of course, he raised his concerns relative to that. I want to again reiterate that in this incarnation and the amendments that we have brought, we have now, even though we have not expressly stated what will be the offences or what offence would be created if a police officer fails to act or conduct their business in a particular way or by a particular time. Remember, it is nonetheless a legislative responsibility that we have now imposed on the Office of the Commissioner of Police and the Commissioner of Police. And that being said, the Commissioner of Police failing to act and failing to, of course, complete this new legislative responsibility that has been placed on him, he would certainly be in breach of his legislative duty. And most certainly what this will do, Mr. Vice President, is trigger most certainly many internal channels within the service itself to deal with office holders who do not simply fulfill their legislative responsibilities. And that being said, Mr. Vice President, I really did not believe that it was necessary in this bill. That is my personal view, for us to actually indicate expressly so what will be the consequences that these officers would have to face, because of course we are imposing upon the commissioner, we're imposing upon the verification officer a legislative responsibility, and in failing to do so, certainly there would be repercussions within the service itself that will deal with officers who fail to, at least to my mind, to deal with, to comply, with these obligations. Now, Mr. Vice President, that I believe in a nutshell was some of the concerns that I wanted to address that were raised by the honorable senators in this chamber. And again, I'm most certain that the Honorable Attorney General in his winding up would certainly deal with the issues that I did not address. Mr. Vice President, if I now may respectfully add my 2 pence, Mr. Vice President, to the issue of the use of the word without delay. And to do that, Mr. Vice President, I would look at Clause 4, proposed Section 48, subsection 8. And of course, as we all know, it says where there is a change in the information published on the website in relation to a sex offender or registered sex offender, the Commissioner of Police shall without delay update the information. Now, the Attorney General, of course, most competently would have looked at Section 23 of the Interpretation Act, and he would have also addressed case law as it relates to the composite use of shall without delay. In explaining the use of without delay in this legislation. But if I may also add to that, Mr. Vice President, the use of without delay in this legislation is not novel to law. If we, for example, turn to the Police Service Act, so again, now I want to look at just the interoperability of law and the use of without delay that also finds itself in other pieces of law. So if we look at the Police Service Act, Mr. Vice President, for example, if we look at Section 53, it speaks to a punishment of officers. It specifically states that a police officer who knows of any actual or intended mutiny, rebellion, insurrection, or terrorist act and does not without delay give information thereof to a police officer senior in rank commits an offense. So we have in other pieces of law the use of the without delay, and to my mind, that being said, I believe it is good, it's well placed in the legislation because it is not a novel, it's not an anomaly. In the Constitution as well, Mr. Vice President, if we look at Section 5(2)(c)(2) of our Constitution, it speaks to a person being allowed to a right to retain counsel without delay. So even in the Supreme Court of our land, we have had drafters relying upon the use of the terminology without delay. And of course, I'm saying this coming after the Attorney General, who would have expressed, looking at the Interpretation Act and looking at, I believe, the case of the Freitas. I also, Mr. Vice President, found another local case, and it's the case of Gibbs against the Attorney General. It was before Justice Musai. It's a 2000 case. And the question in this case, however, was whether the conduct of the Commissioner of Police in transferring the applicant without serving a 14 days notice required by the regs amounted to a breach of the constitutional rights of the applicant. Now, of course, this is very different from the matter, the bill that appears before us. But in this particular judgment, Mr. Vice President, Gibbs against the Attorney General, the applicant, who's a police officer, was served, Mr. Vice President, with 2 warning notices in accordance with Regulation 81 of the Police Service Regulations. Now, Regulation 28 in that case, well, as we know, dictates inter alia that where a commission proposes to transfer police officer, the commissioner shall accept where except where of the service do not permit, give not less than 14 days notice to the officer who is to be transferred. And of course, this is an inter alia explanation of Regulation 28. Now, in this particular case, Mr. Vice President, in traversing this legal issue, the court relied upon a statement made by Lord Diplock in the case of Harry Kisoon versus the AG, page 268 to be exact, and in that, where a person claims redress for a failure of, in this case, a public authority or public officer, it involves the contravention of some guaranteed right. Now, the court also quoted in Gibbs and the Attorney General another case, Mr. Vice President, Wang versus the Commissioner of Inland Revenue, and that's a 1994 case. And in this case, the law lord stated that in relation to an alleged failure to comply with a time provision, it is better to avoid the use of the words mandatory and directory and ask whether, and these are the things that they ask, whether the legislature intended that the person making the determination to comply with the time provision, whether a fixed time or a reasonable time, and 2, if so, did the legislature, Mr. Vice President, intend that the failure to comply with such a time provision would deprive the decision maker of jurisdiction and render any decision which is purported to make full null and void, Now, let's analyze that case in the bill that appears before us. Now, following the decision, Mr. Vice President, in Gibbs, and most importantly, Regulation 28 of the Police Service Regulations, the legislature is not precluded, as we know, from imposing a definite timeline on the Commissioner of Police for the entry of information on the sex offender register. It must be noted, however, Mr. Vice President, that the difference between the latter case and the present bill and the present situation is that in the latter, it relates to where a commissioner of police has the discretion to make a determination, whereas here, Mr. Vice President, Madam President, by virtue of Clause 4 of the bill, which seeks to amend Section 48, the judicial officer has already made the determination as to the accused, as to the guilt of the accused, and what the police commissioner is called upon to do in this current bill is to simply serve an administrative function. Therefore, the duty of the Commissioner of Police, Madam President, is a matter of administrative procedure, or in other words, to simply complete a data entry process. And that being said, I respectfully believe, so the Commissioner of Police is not called upon to pronounce guilt. He is not called upon to act in any way which will affect the fundamental rights of a person in the instant. So therefore, by saying without delay, it is not creating a situation where he failing to act, the Commissioner of Police is somewhat stepping on the rights, the fundamental rights of an accused. What the Commissioner of Police indeed in the current instance is being asked to do is to fulfill an administrative function, which is to, of course, update the register. And I'm not saying, mind you, I'm not saying that that is not a critical function, not the register, sorry, the website. I'm not saying that that is not a critical function, because of course we know the purpose of the website is to alert persons, the public, as to who have offended committed sexual offences, who have been charged with sexual offences and so on. So I'm in no way at all not acknowledging that what the Commissioner is called upon to do here is not a significant role, and by simply saying it's an administrative function, that's not my intention at all. But the reason why I've raised the case of Gibbs versus the Attorney General is that that was a case in which the Commissioner was called upon to make a different decision, actually, as opposed to in this instance. So of course, in that instance, a specific time frame was critical, whereas in this instance, I would continue to support that by using the word without delay, we have not erred as legislators. And of course, this case is just to add to the good explanation, well comprehensive explanation as to why we relied upon delay by the Attorney General, who looked at the Interpretation Act, the case of the Freitas.
Minister, you have 5 more minutes.
Thank you very much, Madam President. So certainly that is, Madam President, my 2 pence as it relates to why I would support the use of the word without delay. As I said before, I would have looked at other pieces of law in which we have used without delay. I have relied upon, Madam President, the Constitution that used the term without delay, and in my own way, I've tried to contribute to case law as it relates to Gibbs and the Attorney General, just to add to what the Attorney General has already spoken to as to why we have used this legal terminology in the bill that appears before us. Madam President, I believe I have already dealt with the concerns about the police and, of course, the resources for the police. If I may quickly look at, in the 5 minutes, well, less than 5 minutes that I have, Clause 5 of the proposed bill, Madam President, which seeks to amend Section 56(2) of the Act. Of course, the amendment, again, it's, where we're amending to we're seeking to delete the word offense and substitute the word sentence. And, the reason why I'm getting into this is because I started off this contribution by saying that the law is not static, the law is dynamic, 1, and 2, as responsible legislators, as tardy, as lawyers, for example, when you amend a statement of case or a claim, it's not really what you don't really ever hope for that. As a lawyer, you draft a claim form and you hope that what you submit, that is the be-all and end-all. But as time go by and you recognize that there's a need to bring an amendment, of course you acknowledge and you take responsibility for that amendment. And that's why, I want to reiterate that yes, as simple as this amendment is, we have taken responsibility as a government in recognizing that even though we came to this parliament previously with this bill, we recognize that there is still need for us to continue to tweak, and we take responsibility for that because we are a responsible government. And in that clause 5, Madam President, Section 56 of the Act is amended in Section 2, and why is this amendment critical in my respectful view? Offense means generally that of which is equivalent to a crime, for instance, an act or omission punishable under the criminal law, and an act done by a registered sex offender could be deemed as an offense, but it does not confirm, Madam President, any meaning of indication of an offense having been committed and a court of law finding guilt. And as a consequence, based on the interpretation of this word, I believe that it was critical as responsible legislators for us to acknowledge that, hey, listen, we need to come back here and make this necessary amendment. Not because we have been sloppy in our drafting, and that's why I support when, and this is not putting blame on anyone, but, at least Senator Dr. Dillon-Remy recognized that this bill was before all of us in this chamber, and certain things may have missed us. And once we pick up on it, we take responsibility, and we've come here to make the necessary amendment. Of course, this amendment in Clause 5, in my respectful view, it's this construction against absurdity which may be created in the law. And then, of course, if we look at one case as I close, it is in the case of Black Crosson International Limited against Paperwork Waldorf, against the AG. It was stated the same words should be consistently used to mean the same thing in drafting legislation, and that different words will be given different meanings. This is the presumption against a change of terminological use. And hence the reason in Clause 5, Madam President, as simple as it may seem, the word offense, we intended to delete the word offense and substitute it with the word sentence, recognizing that we have a duty to this country as it relates to statutory interpretation and the meaning that this the chaos that this simple word could create in the law, why it was necessary for us to come here and make the amendments. With those few words, Madam President, I thank you for the opportunity to contribute.
Attorney General.
Thank you, Madam President, and thank you to all members of the independent bench in particular, and to members on the government side for a recognition of a living reality, and that is that law is a living thing, and our job as legislators is to keep the law under review and to continue to respond to societal changes. We live in an interesting time. I will admit to being something of a dinosaur in the times that we live now, in particular with reference to the reality of something known as social media, which is so relevant to the conversation that we are having today. And so it is very important that we recognize, as we continue to return to the wheel of effort and industry, that we must not be too self-critical or criticize each other too harshly, when what we really are trying to do is to keep up with the times. Only this morning I was having a conversation with a gentleman for whom I have great respect, who is much more au fait with the reality of social media than I am, and I was genuinely taken aback by some of the tales that he was, not tales, some of the accounts he was giving me of the passage of the population of young people that he would observe in the malls and elsewhere going into parties and how they are dressed. And all of it is on video now and is being exchanged and shared on social media. This is the reality that we have to continue to address. And what we are about here today is one of those attempts to continue to keep under review, and I emphasize that, to keep under review the pace at which our society is developing, and to keep it under review so that we might continue to regulate ourselves and those whom we love, our citizens, in a manner that is responsible and responsive, so that we can continue to leave and to bequeath a rich nation to the citizens of this country. May I say thank you in particular to those senators who have made substantial contributions to the effort that we are making here, and I would just like to respond to some of the comments that have been made. And I would start with the opposition comments that have been made. There has been, of course, the return to the criticism that the term without delay is not sufficiently clear. And there was a suggestion by opposition Senator Lutchmedial that it should be given a more, to use her term, definitive timeline. I've spoken to the meaning of shall without delay. I'm not going to return to that nor repeat it. I was just slightly taken aback in the context of the suggestion that shall without delay is so without meaning that it should be given a more specific timeline, to then find that when the senator turned to subsection 57.3 and subsection 57.3 Roman 2, which is introduced by clause 6 of the bill, there was a suggestion that this 7-day period was not a realistic period and it should somehow or the other be relaxed to allow for a greater period of time for the verification of the information. So I don't quite follow this suggestion on the one hand that shall without delay doesn't demarcate a timeline, but then when you have a timeline of 7 days, that should somehow become more elastic. I rest on the fact of what I have already submitted, that the words shall without delay are sufficiently clear in the drafting language and sufficiently clear for any reasonable interpretation that would have to be made by a court of law if it were to meet that case. This suggestion was also made, Madam President, that the impact that a public sex offender register will have is dependent on populating same, which requires detection and conviction. Well, that is precisely the job of the Trinidad and Tobago Police Service. That is the purpose of the sex offenders register and the sex offenders website. I have already said that with respect to the question that has been asked of me by Senator Dillon-Remy, I will make inquiries and I undertake to return in due course with sufficient information to address that and to ensure that there is a synchronicity between the relevant parties who are charged with responsibilities under the legislation to ensure that both registers, that is to say, the sex offenders register and the website, are populated properly. There is a concern that I would address immediately, which was raised by independent Senator Richards, for whom I have the greatest respect, and I would address that immediately. He was suggesting, and with great justification, that there should be some greater control of the default that the police might be guilty of in complying with the responsibilities that are visited on them by this legislation. And while I accept that we want our police service to function as efficiently as they possibly can, and we will always encourage them to, I would urge caution that we can't expect, short of violations of the law and breaches of specific responsibilities, to cast penalties in the legislation on the failure of a police officer to perform a time-bound responsibility within a reasonable time. At the end of the day, it would seem to me that we have to encourage our police officers to act responsibly, having regard to the duties that are imposed on them. And if they don't, then there is recourse that will have to be availed, recourse to the Commissioner of Police, recourse to the Police Service Commission, recourse to the Police Complaints Authority for disciplinary action to be taken against the police officers who are being derelict in the discharge of their responsibilities under the legislation. But I don't think that in this legislation we could entertain putting in a penalty to be exacted against a police officer if he does not do something within 7 days. But of course, that is a matter that I will have to advise myself on with more expert advice than I am capable of rendering to myself in consultation with the draft persons within the Ministry of the Attorney General, and it is a question that I would want to look at. I don't believe that we can address that today. And of course, we know that there are other amendments that we will be coming to this House with. Voyeurism is one of those amendments. And if in due course we think that there are tightening up procedures that can be engaged in along the lines that Senator Richards has suggested, certainly we will return to deal with them. We can't deal with those today because I don't see how we can exact penalties by way of breach of statutory duties on the police officers for failing to comply with a responsibility within a reasonable time frame. One of the other suggestions, useful suggestions that came from Senator Richards, which one has to accept, there is the possibility that the website could go down, it could be hacked. Well, again, we have to rely on the fact that so far we are assured, and this website has been in existence for some time, that the police service is applying very serious skill sets and taking a very responsible approach to ensuring that the website is properly managed. And therefore, again, I don't know that we can make prescriptions in the legislation for what happens if the website is hacked. The fact of the matter is that if the website is hacked, there are other laws under which the hackers will be held responsible. So we don't need to detain ourselves in respect of this legislation to prescribe offenses, in my respectful view. The question of locality being too broad, another suggestion raised by Senator Richards, and not narrow enough so that the address of the person is unknown. Well, the Act does not specify any address within the locality, but simply the area where the person resides. And when one looks at Schedule 3 to the Act in respect of the National Sex Offender Register, you will see the detail that is spelled out there. So that I think that with the assistance of an effective police service, who will be recording the sex offenses that are registered and registrable, that the issue of the locality not being sufficiently clear ought not to impede the proper implementation of the legislation. Senator John spoke to detection and conviction, which will feed into the website. Well, those again are joint responsibilities and efforts of all of the stakeholders, in particular the investigative and detective processes of the police once an offense is reported, and then we can rely on the sex offenders register, which is in existence, which we can take the comfort from knowing that even though the website may not be populated in the way in which critically Senator Dillon-Henry has pointed, Remy, I beg your pardon, Senator Remy has pointed out on the research that she's done, we do have that sex offenders register, which is maintained in confidential terms by the police service. When one looks at Section 54 of the Act and Schedule 3, which spells out in great detail items listed beyond item 22, and continuing the details which are known to the police, which are held confidential, and which will enable the police to pursue registered sex offenders who have committed offenses, the heinous offenses that this legislation seeks to inhibit and prohibit. So I think that we can rest assured in response to Senator John's comments that we have sufficiently functional sex offender register, and we certainly, in response to Senator Dillon-Remy, will be looking to investigate the potential room for improvement of the website. Senator, my good friend, Senator Hazel Thompson-Ahye, as did Senator Dillon-Remy, made the point which I started with, and that is law is a living thing. When the Act was first amended in 2022, 33 members of the legislature joined together in a commendable effort to pass the amendments that were passed at the time. And we are not all perfect, and I dare say that not one of those 33 senators would today suggest to themselves that they were so imperfect that would have rendered utterly unnecessary the need to return today, as we do today, to improve the quality of the legislation, as we shall continue to do, because law is a living thing, and legislation must keep pace with the progress or the lack of progress of a society. The mental assessment point that was raised by Senator Hazel Thompson-Ahye, Section 61 of the Act already deals with that, where a person makes an application to be exempt from registering as a sex offender or reporting requirements. The court has a discretion to conduct a mental assessment under Section 61 of the Act. So there is that provision there, which is of assistance in respect of the concern raised by Senator Remy. We find as well that under Section 70, Senator Hazel Thompson-Ahye spoke of a person who is found not guilty by reason of insanity or disability should be included in the register. Well, such a person would not, first of all, be considered a sex offender under the law if you suffer from an insanity or disability. But under Section 60 of the Act, the Parent Act, where a registered sex offender has a mental disorder and is required to report to a police station, he may be accompanied by a representative of his choice. So he or she, that is, so that the Act reaches out to contemplate realities which we are all grappling with and realities which we must be sensitive to as we pass legislation to regulate people's everyday life. Senator Wade Mark has, in his inimitable style, made contributions which I think every other speaker in the House has addressed, and I therefore don't think that I need to trouble this House with a response to Senator Mark. Senator Dillon-Remy made the point that I have already addressed, which I am grateful for, that the time frame of 7 days and 3 days, she questions whether these are sufficient to verify the accuracy of the information. I say two things on that. We have to remember, referencing back to Section 42, first of all, Section 2 of the Act, which defines sex offender. A sex offender is defined as someone who has been convicted. And then we go to Sections 46 through, to later sections of the Act, and we remind ourselves that the sex register, offender register, and the websites are registers by which we record information that comes out of recorded convictions, so that we can be satisfied, in my respectful view, unless there is something fundamentally wrong with our court system, that if the courts have convicted someone of being a sex offender and that person is then registered on the website, that there has been a sufficient verification process. And I would not suggest, given our sense of urgency to make this legislation as effective as possible in its implementation, that we need to trouble ourselves to further verify the fact of the commission, the conviction which has been recorded by a competent court of law. Senator Dillon-Remy spoke of the recording of the information after verification should be done digitally. That will have to be a decision that the Trinidad and Tobago Police Service would no doubt have to look at. I dare say, as a nation, as we move towards digitization of our entire governmental and public administrative system, that we will get to the point at which it will all be digitized. A step at a time. We are doing the best that we can as we move towards a better society in which our vulnerable and our citizens can feel safe. Madam President, in the circumstances, I do not think that there is much more that I can say at this stage, and in all of the circumstances, I beg to move.
Honourable Senators, the question is that a bill entitled An Act to Amend the Sexual Offences Act, Chapter 1128, and for other related matters be now read a second time. Those in favour say aye. Aye. Those against say no. I think the ayes have it.
Entitled Act to Amend the Sexual Offences Act, Chapter 1128, and for other related matters.
Attorney General.
Madam President, in accordance with Standing Order 66-1, I beg to move that the Sexual Offences Amendment Number 2 Bill 2021 be committed to a Committee of the Whole Senate forthwith to be considered clause by clause.
Honourable Senators, the question is that the Sexual Offences Amendment Number 2 Bill 2021 be committed to a Committee of the Whole Senate forthwith to be considered clause by clause. Those in favour say aye. Aye. Those against say no. I think the ayes have it. This Senate will now go into Committee of the Whole to consider the bill clause by clause. Members, may I remind you that there are 6 clauses in this bill, and we have an amendment circulated by Senator Welch. Is everyone aware of the amendment? So we can proceed. Yeah?
Clauses 1 to 3.
The question is that clauses 1 to 3 stand part of the bill. The question is that clauses 1 to 3 now stand part of the bill. Those in favour say aye. Those against say no. I think the ayes have it. Clauses 1 to 3 now stand part of the bill.
Clause 4.
The question is that clause 4 stand part of the bill. Senator Welch.
Madam Chair, I have proposed an amendment to clause 4. The effect of clause 4 is that there will be a new subsection 48(8) to the Act, and it is in respect of that 48.8, I have suggested two fairly minor amendments. And that is, after the words "the Commissioner of Police," I have suggested the following insertion. The Commissioner of Police, on learning of the new information or on it being brought to his attention, shall, and I have suggested after shall the insertion of the words, subject to that information being verified, without delay update the website in relation to that sex offender or registered sex offender. So in other words, if the information is already registered on the website, and if there has been a change in that information in respect of the sex offender, the duty of the Commissioner of Police shall arise only after he learns of the new information or it is brought to his attention. As the amendment is, it simply says, he shall, without delay, do certain things. I am suggesting that by inserting the words, on learning of the new information or on it being brought to his attention, is more realistic and practical, because that is when he ought to be required to update the website, when he learns of the new information. So that is the first aspect of the suggested amendment. And the second aspect of it, which reads, shall, subject to that information being verified, simply means that before he seeks to update the website with any new information, that information should first be verified before any changes are made on the website. It should not be tinkered with so easily. And those are my suggestions regarding the proposed section 48.8.
Attorney General.
Thank you, Madam Chairman. I have listened to Senator Welch, and I've given consideration since he circulated the amendment to his proposed amendment. I'm unable to support the request for the amendment, and I have three reasons in particular. We start, first of all, one, against the background that a sex offender becomes a sex offender on conviction. That's in the definition section. So we start with that fact of certainty that this is someone who has been convicted by a court of competent jurisdiction and therefore becomes registrable under the legislation. And I don't think, therefore, that unless there was something wrong with the court's order, that there would be much that the Commissioner could reasonably be called on to verify this. Secondly, when we look at Section 48.3 of the current law, we see that the Commissioner of Police shall, in relation to the website referred to in subsection 1, be responsible for maintaining the website, B, ensuring that information is published on the website in accordance with this Act and any other written law, and C, ensuring that the information published on the website is accurate, so that one would expect that the responsibility and duty cast on the Commissioner by Section 48.3 will carry through to Section 48.8, which is the amendment that is being introduced, and therefore it would be really to gild the lily unnecessarily to ask him to go beyond that duty to repeat that which he's already charged to do under 48.3. For that reason, I think it is unnecessary. And finally and thirdly, we are all concerned that the shall without delay should be accomplished within the shortest possible time. We've spoken to that, and to introduce an unnecessary further requirement in 48.8 is going to slow down the process which we are concerned to expedite. So for those reasons, I can't support the amendment.
Senator Welch.
Yes, I've heard what the Honorable Attorney General has said, but let me say with respect to the first aspect of what he has said. First of all, when the information is initially published on a conviction being received, that is one matter. One expects all that information before it is initially published to be verified, etc. And I understand that. But we are talking about where there is a change in the information, where you are going, where the information on the website is already published, and you are now saying that in relation to the particular offender, his personal details have changed. That is where this 48A comes in. And if you are going to make a change, then I am saying at that secondary stage, one needs to, first of all, he has to be, it first must be brought to his attention, or he must first learn of it before the duty arises to effect a change on the website. And secondly, the information should be verified, because we are talking about a change, not the initial conviction or information, which we accept that once it appears on the website, for the first time, it would have been verified already. We are talking about where there is a change of it, that should be verified. That's my answer, Madam Chair.
Attorney General.
I'm grateful to Senator, but I don't change my view. I continue to say that the need for his further amendment is not necessary. I'm not persuaded.
Sure. So at this stage, I will, Senator Welch, you are pursuing the amendment?
Yes, Madam Chair.
Sure. So, Honourable Senators, the question is that Clause 4 be amended as circulated by Senator Welch. Those in favour say aye. Those against say no. I think the noes have it. Honourable Senators, the question is that Clause 4 now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clause 4 now stands part of the bill.
Clauses 5 and 6.
Honourable Senators, the question is that clauses 5 and 6 stand part of the bill. The question is that clauses 5 and 6 now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clauses 5 and 6 now stand part of the bill. Honourable Senators, the question is that the bill be now reported to the Senate. Those in favour say aye. Aye. Those against say no. I think the ayes have it. The bill will now be reported to the Senate. Attorney General.
Madam President, I wish to report that the Sexual Offences Amendment Number 2 Bill 2021 was considered in Committee of the Whole and approved without amendments. I now beg to move that the Senate agree with the committee's report.
Honourable Senators, the question is that this Senate agree with the committee's report on the Sexual Offences Amendment Number 2 Bill 2021. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Attorney General.
Madam President, I beg to move that a bill entitled An Act to Amend the Sexual Offences Act, Chapter 11, Number 28, and for other related matters be now read a third time and passed.
Honourable Senators, the question is that a bill entitled An Act to Amend the Sexual Offences Act, Chapter 11, 28, and for other related matters be now read a third time and passed. Those in favour say aye. Aye. Those against say no. I think the ayes have it.
A bill entitled An Act to Amend the Sexual Offences Act, Chapter 11, 28, and for other related matters.
Acting Leader of Government Business.
Madam President, I beg to move that the Senate do now adjourn to Tuesday, June 28th at 1:30 p.m., which is meant to be Private Members' Day. We will continue the debate. This is in agreement with the independents. We will continue the debate on number 1, which was in progress before, and hopefully move to completion, hopefully. I also wish to give this Honourable House notice that we will meet on Thursday, June 30th at 2:30 p.m. when we hope to debate and bring to conclusion the National Insurance Amendment Bill 2022. Thursday the 30th. Thank you.
Are you, Senator Mark? Are you sorry? Sure. Honourable Senators, before I put the question on the adjournment, leave has been granted for 2 matters to be raised. One? Yours? Senator Mark. That's all right.
Thank you, Madam President. Madam President, I bring to your attention today the situation impacting on the Occupational Safety and Health Agency, where there is a profound crisis affecting the operations of this agency, designed to protect and safeguard the health, safety, and well-being of close to 600,000 workers and their families. The utter contempt, disrespect, and contumely shown towards the working class and their trade unions, Madam President, is clearly manifested in the state of play at the Occupational Safety and Health Agency. We have read reports, and those reports are yet to be denied, that in a period of 15 months, some 14 inspectors, safety inspectors, have tendered their resignations from this agency, including the chief inspector. Now, Madam President, how can a government allow such an important agency to be without that core technical competent capability that is so critically needed to deal with safety and health and security and the well-being of the working class? There's a law in our country that establishes the Occupational Safety and Health Authority and Agency. Madam President, I beg your pardon. Madam President, it is alarming. I am in a state of consternation to understand why this government has allowed this agency to deteriorate in the way it has. Madam President, this government of the PNM has allowed safety inspectors not to have security of tenure. They have these safety inspectors working on a month-to-month basis. How can you expect these inspectors, Madam President, to carry out their duties diligently and effectively in the interest of safety and health of our nation, and particularly the workers? Madam President, is it any wonder that when this bill, before it became law, on 3 occasions, 2 I recall vividly, The entire PNM was in opposition. They abstained from voting on the Occupational Safety and Health Act. And on another occasion, they all voted against the Occupational Safety and Health Act. Is it any wonder, Madam President, that the government of today, the same PNM who voted against this bill, which is now an act, is allowing that company, that agency rather, to deteriorate, to collapse, to fall down? There's a story in the newspapers, I don't have a copy of it with me, Madam President, where a chap called Francis, I think he's a labor relations officer at some trade union, and he was making the point that the 4 divers that died, that whole inquiry and investigation has now been compromised because the key personnel who were responsible, Madam President, for conducting the inquiries, all of them were on month-to-month, including the chief inspector, and they have all tendered their resignations. So what is going to be the outcome? You know what is the outcome, Madam President? You and I learned today that the gentleman who came from Jamaica, a very distinguished lawyer, Justice Morrison, who was supposed to head this commission of inquiry into this incident, he tendered his resignation and he has gone back to Jamaica, and they have replaced him with some other person. Madam President, I am asking this question. Did the government put pressure on Justice Morrison? I am asking a question.
Madam President.
Senator Mark.
Yes.
This is not
okay,
the
I understand you, Madam
debate
President.
to ask that question, right? So I need for you to get
I apologize to you, Madam President. Madam President, it is very, very difficult to have workers in this country not being given the kind of protection that the law that we passed in this parliament with a 3/5 majority. We were here when the PNM brought that law in 2004, and we supported that law in 2004. It passed, Madam President. It was operationalized in 2006. And in 2022, there are hundreds of thousands of workers in this country without any protection because the government has literally collapsed the Occupational Safety and Health Agency. Who is going to protect the workers? Who is going to look after the safety, the health, and the well-being of the workers when the core of the Health and Safety Occupational Agency, 14 gone, including the inspector? Madam President, this is unacceptable. This is inexcusable. This is indefensible. This is bordering on criminality. How can we sit in this parliament, Madam President, and in Trinidad and Tobago and allow such an important agency to just collapse? And there's no protection, Madam President. Madam President, I feel very strongly about it. As a former trade unionist, I understand the importance of safety and health and welfare in the workplace, both in terms of the role of the employer as well as the worker. And you need to have, Madam President, that ability when workers and their trade unions or the employers call upon the Occupational Safety and Health Agency to come to make an inspection, to come to examine what is taking place in the workplace. But who is going to come, Madam President? Madam President, I call on the Minister of Labor to come clean on this matter. Let us know what role is the government playing in compromising, subverting, Madam President, this very important agency. I call on the government to ensure that they take immediate steps to bring about security of tenure for these inspectors. They cannot be working on a month-to-month contract any longer. They must have security of tenure. They must be permanently employed. They must have the kind of security that is necessary for them to carry out their responsibility on behalf of the people of Trinidad and Tobago. This is an abomination, Madam President. This is going on too long. And I want the minister to tell us, Madam President, to what extent this situation is compromising the deaths, the diverse inquiry into that whole incident. I'd like the minister to tell us that in terms of. Thank you very much, Madam President.
Minister of Labour.
Thank you, Madam President. I thank this House for the opportunity to respond to the motion raised by Senator Wade Mark concerning an explanation on the arrangement whereby inspectors of the Occupational Safety and Health Agency are employed on a month-to-month contractual basis. Madam President, the Occupational Safety and Health Agency is a statutory body under the Ministry of Labour, which was established in August 2007. In accordance with Section 69 of the Occupational Safety and Health Act, which replaced the outdated factory ordinance. Its establishment was a landmark achievement of the government as it demonstrated a strong commitment to the safety and health of the country's workers, as well as those who interact with enterprises on a daily basis. As a first step in the establishment of the OSH agency, the OSH authority sought to fill positions on the organizational structure of the agency, which was approved by Cabinet, comprising 152 contractual positions. Once a contract position is utilized, renewal must be sought from Cabinet for additional life in the expired position. This is a normal occurrence in the contract employment that as done in the government service. Madam President, in December 2019, the OSH agency began the process of working with the Ministry of Labour and the Public Management Consultant Division, PMCD, of the Ministry of Public Administration to extend the life of the contract positions. As an interim measure, the OSH agency offered month-to-month contractual arrangements to inspectors pending approval of the life of the contractual arrangement or measure. I wish to emphasize that the month-to-month contractual arrangement was an interim measure, not a long-term arrangement, and definitely not one that will become the norm. It has been used to facilitate the continued functioning of the agency to undertake its critical work pending the relevant approvals. Due to the impact of COVID-19 and varying work schedules within the ministry, the process for extending the life of contractual positions and engaging or re-engaging inspectors has taken longer than we would have liked. I am pleased to report, Madam President, that on April 21st, 2022, Cabinet approved the extension of the life of the position of inspectors, and 3-year contracts have since been offered to inspectors. I wish to assure the Honorable House, this Honorable House, that the untenable situation of month-to-month contract for safety and health inspectors of the OSH agency has been addressed. I would also do my very best to ensure that such a situation does not reoccur, as safety and health in the workplace remains a top priority of the Ministry of Labour. With regard, Madam President, to the issue of resignations within a 14-15-month period, this is not unlike any other institution where people have the right to determine whether they want to continue to work in a particular establishment or not. That does not mean in any way that the service to that industry or organization is compromised in any way. If every organization had one person who was ultimately responsible for getting everything done, then that organization will not exist for very long. The USH agency has competent people who can take up the mantle and who can address the issues as raised from time to time. I will not get into any issues which relating to any specific incidents, as this is not on the table at this time. I wish, however, Madam President, to take this opportunity to inform the House of a tremendous accomplishment concerning occupational safety and health, which was realized at the recently concluded 110th session of the International Labour Conference on the International Labour Organization, for which I had the honor to lead our national delegation in a virtual format. This has to do with the adoption at the conference of a safe and healthy working environment as an addition to the fundamental principles and rights at work. What this means, Madam President, is that occupational safety and health is now ranked as a fundamental right in the workplace. We are indeed proud to have been part of the process leading to this milestone in the history of the International Labour Organization. As Minister of Labour, I will continue to place priority and attention to the work of the USH agency and do all within my purview to ensure that the USH agency is positioned to effectively discharge the mandate in accordance with the USH Act. I thank you, Madam President.
Honourable Senators, the question is that this Senate do now adjourn to Tuesday, June the 28th. It is clear to me that some of us want to stay here a little longer. I'm very happy I can sit back and just wait for full silence. The Honourable Senators, the question is that this Senate do now adjourn to Tuesday, June the 28th, 2022 at 1:30 p.m. Those in favour say aye. Aye. Those against say no. I think the ayes have it. This Senate now stands adjourned to Tuesday, June the 28th, 2022 at 1:30 p.m.